Okay, so today we're going to talk about the B101. So this is the AIA, American Institute of Architects, Standard Form of Agreement. It is used in many construction projects. This is the document that you will be entering into between you as the architect or your company as the architect and the owner. Now there are provisions in here that reference the contractor and how the contractor plays into it, because, as I think I've explained in the past, the AIA documents as a suite work together. So there's owner-contractor agreements, there's owner-architect agreements, there's architect and consultant agreements. So if the architect hires an electrical engineer or mechanical engineer, there are contractor-subcontractor agreements. There's a whole host of them. And so they all have to interrelate. They use the same definitional terms, same provisions, and sometimes they even point to each other. They actually even reference another document. So it's important to kind of understand how the suite works. And I do have another lecture later on that kind of also gives a big picture. But just so you understand, so this version we're going to go through is the 2017 edition. So the AIA has been doing this since the early 1900s. Roughly every 10 years in the beginning, and then it became standardized, I think, in the 50s. Every 10 years, they will update each document. So they have their suite. They've expanded how many they have. So the next time that the B101 will be issued will be 2027. So this document was released in October of 2017, and it'll be good for 10 years. What the AIA does is they have actually a committee, and the committee is made up of architects, engineers, contractors, subcontractors, owners, outside people, everybody that needs to have a voice in this document or these documents sit on this committee. And actually a couple of attorneys that I work with are on that committee. I meet with them sometimes. It's every Wednesday morning. And they go over terms of the provisions, and they talk about, should we change this one, should we revise that one. We look into the history of what's going on in the industry, both on what are trends, what are important, and I'll point out some of the kind of changes in this version's documents as we go through it on trends. They'll also look at cases. So what will happen, and that's why this set of documents are so popular and so important, and why when you take your licensing exam, why they use these as the thing to test on, is they've been around for so long, and what will happen during this 10-year period of time, a provision or various provisions will be more, I won't say popular, but will come up more often in litigation. And as a result, the courts will rule on it, and the courts will interpret the meaning of that provision and how it applies to owners, architects, contractors, etc. And from there, what ends up happening is the AIA committee read those cases, and they say, well, that's not what we meant when we drafted this clause, or that's exactly what we meant. And so they use case history as a way to maneuver or change the contract so it helps both sides, any side, owner, architect, whomever it is that's a part of that. And if you think about way back to our hierarchy, common law, which is down toward the bottom, and contracts were two parts of the hierarchy. And so specifically the AIA as a overall committee, as a governing body that looks over the practice of architecture, but as well as the construction industry, they've recognized that let's take these two elements, common law and contracts, and make them work together so they speak to what's going on in society. So those are some overall important rules. Some are updated on the fours. There's a suite of them that are instead of on the sevens. There was a couple of documents that were just updated in 2014, and then there'll be 2024. What's odd about those is sometimes you'll have a document that was updated on the fours, and it for a portion of its time it'll be using a document that was previously updated on the previous seven, and then halfway through it'll flip to the new seven. So some of those documents that are in the off years that are updated on the fours as opposed to the sevens will span both sets. You don't have to worry about that any as far as now, but when you get out there, you may be in the situation where, like, do I use A or B, and then you can call me up and I'll tell you which one is best to use. So, okay, let's get into the actual terms and conditions. So today we're going to go through the first 4 articles of the document. I believe there's 13. You're like, oh my God, if we're going to only do 4 today, how are we going to get through the other 11 next week? There's a lot less content in the remaining 11. We're going to do the bulk of the kind of the guts in this first 4. Actually, I keep saying 11, should be 9. But and then they're broken up. So the first is going to be initial information. The second article is about the owner's obligations and responsibilities. The third is going to be about the architect's obligations and responsibilities, and that's going to take the biggest bulk of our time today. And we'll take a break for 5-10 minutes during that period of time, so you guys can kind of stretch and whatever, since we'll take the full 3 hours or 2 hours and 50 minutes. And then we'll do the last section, Article 4, which is kind of now starting to talk about what are they're called deliverables, or what product or that you need to provide to the owner, and how those are handled. So, without further ado, and like I said, I'm just going to go through the provisions. Now, you'll see on this page a couple of things. I don't want you to kind of understand both in contract drafting and how these slides are set up. So if you take a look at the very first one, it says this agreement is based on the initial information set forth in this section 1. So if you can notice, and on the other elements on this page, other words on this page, agreement and initial information are capitalized. So when you're drafting a contract, and I may have talked to you earlier about this, if there is a defined term, then it stays capitalized throughout. So somewhere in this document is a specific definition of the term agreement, and also the term initial information. And if you recall from the first slide, this article is called initial information. So this whole section is defining what is contained in the initial information. So when you read a contract, any contract, whether it's an AIA contract or any contract over the course of your career, if you are put in the position of reading contracts, anytime you see a capitalized term in that contract, read through the agreement to find out what that defined term means. It's important. For example, the term project that's here under 1.1, it has a specific definition. It'll be on the opening page. It'll say the project, and there'll be a specific description of what it is. That's different than the definition of a project in another contract. Initial information will be specific to this agreement. So as you look at defined terms, they will be specific to the agreement you're working in. And that's important, again, for legal purposes of how the contract is reviewed, interpreted, and then if there's a dispute, how a court or arbitration panel will review. The next thing I want you to see on the screen here is if you take a look at under 1.1.3, I have the language cost of the work is highlighted in bold. That's not, anytime you'll see this in these slides, that is not the language as drafted in the actual AIA agreement. I've highlighted it because I want you to recognize that's something important for what we're talking about. Either A is a defined term, or that I want you to recognize that it's important for the lecture and potentially on the exam. So the highlights in bolds, and there's a couple slides that actually have in blue, all those were added by me, and it's just kind of a headline to you guys. This is important. So that's just kind of as a basic of what we're going to go through as far as how the slides are set up and what's in the actual agreement. Real quickly, the content of what the slide is, just for the lecture purposes, as I said, this is the beginning to define what's the program of the project, what's the physical characteristics of the project, and then what's the budget for the cost of the work. And budget is a different concept than cost of the work in the contract, and we'll talk about that a little bit more in detail. But think of the cost of the work for your purposes is the actual cost of the materials and the labor. It has nothing to do with the price of the property. It has nothing to do with the amount that you as the architect are going to be paid. So it's only as far as the cost that the contractor is being paid to buy the materials and perform the labor. And that's the reason why it's important and why I have it highlighted here is because we're talking about the budget in Section 6.1, which we're not going to get today, but we'll talk about it. Article 6 has various owner's considerations, including its budget. So when an owner comes to you and wants to retain you to design that $1 million house, the first question you want to ask is, what's your budget? They say, my budget is $1 million. The second question is my fee included in that $1 million? Because owners don't understand this, and what happens, and again, this gets into your concept of what's important for defined and not defined in the terms. If you start designing a house and you design it for $1 million, and it goes out to bid and it comes in at $1 million, and at that point, and only that point, the owner says, well, my budget included paying you your $150,000, so you should have designed me an $850,000 house instead of $1 million house. Then you understand how you look at it. So it's important to ask when you have a budget discussion with an owner, so they understand the difference legally or contractually. Cost of the work does not include anything other than materials and labor to build the structure. Okay, moving on. Additionally, in the owner's initial information or the project initial information, is you want to have into 1.1.4 is various dates. So these are important for a whole bunch of things. Design phase milestone dates. You want to make sure you have, because you're going to have, as an architect, you're going to have obligations to hit your marks. And are you going to be hitting those dates? Construction beginning or commencement, substantial completion, as you can see, that's a capitalized term. That also is important. And substantial completion is probably one of the more important terms used in construction. It means when the project can be used and is fit for its intended use and purposes. Doesn't mean it's 100% complete. Doesn't mean that all the outlet plates are put on the plugs or every door is completely perfect. That's what you do in a punch list. But it's the building is in such a state that the owner can use it. So a substantial completion is obviously important. If you think about the examples that I've kind of thrown out over the course of the semester thus far, I always talk about, you're going to design me a toy factory, I need to have it by October 1st, or by August 1st, so I can start my initial runs and everything else. That date that I always throw out of when I need it by is typically looked at as the substantial completion date. The other thing you want to put in is other milestone dates, anything else that may be important. Sometimes you have, for example, let's say you're designing a apartment complex, and it's a 30-story building. Well, what the owner will want to do is the owner will want to start renting out units as soon as possible. Instead of waiting for all 250 units on the 30 stories to be completed, they want the contractor to finish them in phases. So you can rent out floors 24 through 30 because those are the highest paying rent because they'll have the best views. You want the contractor to finish those first. And so there may be certain dates tied to those or what's called liquidated damages and other stuff. So you want to have those dates in the contract for people to understand. So that's kind of the additional information. Now sometimes in an agreement like this, if you think about sequentially, owner comes to the architect first to design it, and then then that's a contract, and then they enter into a contract with the contractor using the architect's designs. So in the very beginning, maybe not all the dates are going to be known just because there's not enough information. So what happens with any contract is some of this information may be in the contract, some may not, and it may be updated or modified later because any contract kind of is a living, breathing document. It can change and modify over the course of the project. Okay. 115, this just talks about procurement and delivery method. It's, how are we going to pay for this is what that says. And then 116, as I have highlighted here, and this is a new provision that came in 2017, is the owner's anticipated sustainable objective for the project. What does that mean? Well, the AIA decided years ago that they needed to listen to what was going on in society and they started making the contracts themselves green. If you go look at the 2007 version of this, it references that the architect should look into sustainability, but it's kind of a light touch. If you look at the 97 version, there's just some reference to the architect kind of knowing what's out in the industry. And before that, there's no reference at all to green. When we got to the 2017s, they said, well, look, let's point out here that the owner may have its own sustainable objective for the project. And so it highlights and it identifies that, and it gives the reason for the architect and the contract and the owner to kind of discuss, what do you want to be? Do you want to have a green building? Do you want to go and use LEED certification? What type of materials do you want to use? What type of lighting, glass, clear stories, a whole bunch of other stuff. So this provision kind of both does two things. It creates a conversation between the owner and the architect, so it can come up and be, should we put it in? And then it puts parameters around it, which is in the next slide. It talks about, under 1.1.6.1, if the owner identifies a sustainable objective, we have yet another document, the E204, that's called the Sustainable Project Exhibit. And then you have to fill that out, and it talks about the ideas that the parties want to use, and it kind of sets parameters to give the architect knowledge and information. What should it do? Should I try to be going for LEED gold, LEED silver, LEED bronze? What am I looking for? What information does the owner need? What are the priorities or obligations that each party has to do to achieve the sustainable objective? Now, what's important here also is that it says, if the owner identifies a sustainable objective, I will say this, and I do these contracts every single day I work on contracts, I would say probably less than 20% will the owner come to the table with a known sustainable objective. If the architect raises it, maybe another 4 or 5% will create one. But most people don't want to have or don't include a formalized sustainable objective because it can cost more money or they're unfamiliar. And that just, as I said, if you just think about the nature of how I was describing the AIA contracts, before 1997 there was nothing about the architect kind of looking to being green, and it's gotten a little greener. So now we at least have parameters, and we hope that as we continue to build and design, that it becomes a more common dialogue between owner and architect and owner and contractor. So that's why it's in here. 117. Owner identifies the following representative in accordance with Section 5.3, which we'll talk about a little greater next week. But the owner needs to have a point person, a representative. And so under 117, you just put the person's name. That's that. If you think about last week when we talked about agency, that's the individual, whether they work specifically for the owner, whether the owner themselves or a third party, they identify a representative that has authority and speaks on behalf of the owner. So that's their agent. And they will then become critical for decision-making on behalf of the owner, and the architects can, if they get a decision from the owner's representative that's identified here, they know it's binding on the owner. 119 talks about that there's going to be certain consultants that the owner will retain, and on this page, if you look down under 1.1.11.1, there's certain consultants that the architect retains. So again, we're talking about the initial information. You're trying to identify who are all the players in the game. And if you take a look at here under 1.1.10, just like the owner had to identify a representative, the architect needs to identify a specific representative. And so that's the individual that they speak, and they're the voice of the architect. So when they make a statement, the owner can bind the architect to that statement. And so there's this separation between 119 and 1111 with respect to consultants being retained. So both parties identified their agent/representative, And now they have to identify who are they bringing to the table to assist them. Now, there are geotech and civil, typically are brought by the owner. The geotech engineer is going to go out and do soil samples to make sure that the ground is silty soil or clay or what limestone or bedrock or whatever is going to be on it. And the civil engineering, they're going to be responsible for grading and how the land is around them. That's not something that the architect will be offering under what's called its basic services, which is identified in 1.1.11.1. So when you think about the duties and obligations of the contractor, there's going to be some that are going to be owners and some that are the architects. And here you're going to identify who those parties are. As I said, in the very beginning, you may not know those. So these may be blank and be filled in as we go along. And then finally on the slide, under basic services, so the basic services, which we'll get to in greater detail in Article 3, are what every architect is going to provide under a traditional owner-architect agreement. And that includes, obviously, the architectural services, the creative design, but they are also under a traditional architect's basic services required to do structural engineering, mechanical engineering, and electrical engineering. Those are three industry standard that the architect, so when someone hires you, you got to bring at least these four plus your design creativity to the table. That's what they anticipate you to bring. They should not be necessarily expecting that you're going to be bringing geotech or civil engineering. And then under 1.1.11.2, you may have some additional supplemental engineers. You may have like a specialty lighting designer or a kitchen designer or something that, and you'll put those and you'll define those under this 1.1.11.2. And then 1.1.12 is just any other thing that we've forgotten up above. So moving into 1.2, so this is what I talked about, that a contract is kind of a living, breathing document. So it says, the first sentence says, the owner-architect can rely on the initial information. I know who you are, you know who I am, blah, 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 blah. But it says that the initial information may material change, and in that event, the owner and the architect shall appropriately adjust the architect's services, schedule, etc. So what this means is, I come in and I come to you, and I ask you to design for me a 3-bedroom, 3.5-bath house, and I want you to spend $750,000 on it. I'm the owner. Well, that information and other things get put into this contract as the initial information. Then it turns out that I had a good year, or there was other things going on. Maybe the family's growing, whatever it might be. And so I come back to you and say, you know what, I want to change it to a 4-bedroom, 3.5-bath house. You got to add another bedroom. Well, obviously the initial information's changed, and as a result, you get paid more, and the schedule for the timing of your delivery gets changed. So this provision effectively says, and it kind of, sometimes contracts, so you guys can understand, sometimes they're really just obvious. Of course, if I came to you and said, design me a 3-bedroom, 3.5-bath house, and then I came to you later and said, no, let's bump it up to 4 bedrooms, of course you should be paid more money for it. And of course you should have more time to design the additional bedroom because I've changed the scope. So why do we need to write it down? Well, sometimes you want to write it down to make sure that everybody is clear as to what happens. And that's where this term, if you look at the last one that's highlighted, it says the owner shall adjust the owner's budget for the cost of the work. What happens in contracts is sometimes things are really simple and very logical, but people forget to do them. And then you get into a fight later on at court, and they say, wasn't in the contract, didn't have to do that. So for this instance, and throughout all of your careers when you're looking at contracts, things like shall and must and will become important. And so that's one of the more reasons why I want to kind of highlight this provision. It says both A, the first part that's highlighted and italicized is living, breathing document. And B, if it does change, there's consequences. And this obligates the owner. And if the owner doesn't adjust its budget to accommodate all the changes that happen with the initial information, then the owner may be in breach. So both parties have to be respective and understand their obligations to each other in this instance. So that's kind of the purpose of what I've highlighted here. Think about this paragraph and what I'm talking about here more to the terms of how you want to think a provision in the contract or should be read. So it's not like I'm going to test you and say, what happens if the owner goes from a 3-bedroom to a 4-bedroom house, and then you go back and look at 1.2 and says this is it. I want you to more understand that there may be changes in contracts, and as from this example, and as a result of those changes in contracts, there are repercussions, obligations, duties that impact one or both parties on that. Any questions on that? Okay. All right. So the next one here, 1.3, I'm pointing out to you again, this is another document that this E203, and you can see the 2013, so this will be updated in 2023, that can and may be used during the course of a project, but not at all. So under 1.3 it says the parties shall agree upon protocols governing the transmission and use of the instruments of service. What does that mean? So think of it this way. This term that's capitalized, instruments of service, for your understanding, it's your drawings, specifications, any other models or line drawings or three-dimensional drawings or anything that you create that is part of the design and what's used to build the project. So later in the document at Article 7, they have a very specific definition of the term. It's defined. It says the instruments of service shall include, and has this long laundry list of all these things. And so instead of saying in the contract each time, drawing specifications, models, axos, line drawings, blah, 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 they just call it the instruments of service. So that's what that part of that sentence means. The other one, as far as the agreed upon protocols governing the transmission and use. So most of the things that are happening now are done electronically. If I'm sending my drawings as the architect and specifications to the contractor electronically, we want to make sure that there's a protocol of how that's done. When can the contractor rely on what's been transmitted? Where is it stored on a website? What happens if there's a degradation in the data? What happens if someone else is able to access that data and change? So this section 1.3 is about creating the rules for the parties to have the transmission and transferring this data, this instruments of service, back and forth between owner, contractor, architect, subconsultants, subcontractors, owner's reps, a whole host of people. And so in fact they actually have this building information modeling and digital data exhibit that you can use. And it spells it out, and you pull up the E203 and you look through it and you set up the rules. Now, what's important to remember is, like the sustainability exhibit, the E204 document, the parties need not use this if they have something that if they don't have a separate set of protocols. So sometimes what I do for my clients for this is we have a agreed set of protocols of how to transmit the instruments of service, and it specifically says we're not using the E203. So we actually have another set of rules that are maybe less detailed, less specific, because you don't need it. Maybe if we're building a house as opposed to building a 30-story condo building, there's a whole bunch of different requirements. As you can imagine, anytime you add a new agreement, a new document, cause more costs. So this provision sometimes is used or not. But regardless, under 131, it says any use of a reliance on all portion of the building information, blah, 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 blah. The information contained in the model and without having these protocols set forth in the document shall be at the using or relying party's risk and without liability to the other party, the contractors, consultants, etc., etc. So what this is saying is, what 131 says is, If we've agreed upon protocols, whether it's using the E203 or our own set of protocols of how the documents are going to be transferred and shared and used and relied. If you deviate from these, if you decide, I'm not going to go through the protocols, then the party who's not following the rules is doing it at its own risk. This is a buyer beware. This is, if you step out of our rules that we've decided at the beginning of the contract, whether it's the owner and the architect, because these protocols will also be used with the contractor. So the owner of the architect or the owner of the contractor, whoever it is, if someone doesn't follow these rules and something goes wrong on the project, the party who didn't follow the rules suffers the consequences. So how does that work? Well, let's say that there's a protocol that says on such and such a date, every Monday, there will be new documents uploaded to the project website. And the contractor will review and confirm with the architect that they've seen these drawings, and then they can use those to build. And that there's a specific parameters of how the architect and contractor need to confirm with each other that they've been received and they've used, and they go forward. Let's say that these drawings are uploaded on a Monday, and the contractor doesn't look, and they're working on a part of the project because they're looking at the drawings from the prior Monday. Well, since they deviated from the protocols and they go ahead and build something that week that's based on old drawings, and they haven't confirmed with the architect, and then the architect comes on the site and says, you're not building the right thing, the contractor cannot say, well, I'm just building it off the drawings. Because the protocol was every Monday, you need to check to see if there's been updated drawings. So the contractor in that instance would be obligated at its own cost to tear out what they did and rebuild it in accordance with the proper drawings. So that's what these two provisions kind of in the overall will work. Article 2, the architect's responsibilities. So, first thing is, you need to provide professional services set forth in the agreement. Well, it's like, well, of course we are. That's what we are. We're the architect. We're a profession. Well, but you want to say it's professional services because if you remember from our lecture last week on standard of care, or 2 weeks ago on standard of care, you are looked at differently as a professional than as your lay person. So here the contract is saying, you, while you're called an architect, whether you're in a holding out state or a practice state, you are a professional and you're providing professional services, so your standard of care will be tied to that. 2.1 also says you need to be properly licensed in the jurisdiction, and you need to provide the services required of this agreement, not some other agreement, whatever's in the body of this agreement. And so those are the things that are important in this. 2.2. This is highlighted, this is in italic bold and in blue. The reason why it's in blue is this is the standard of care language we talked about 2 weeks ago. This is where, if you remember, I talked about the standard of care is going to be applied to you no matter what, but here what we've decided to do is we've taken this definition of standard of care and we put it into the contract. So if you remember, the standard of care, we talked about it during the tort lecture, because what happens if you violate your standard of care, someone could get hurt or injured. It's not a contract concept. Standard of care, how you act, is a tort concept. But what we've done here is we've taken this concept of how you're supposed to act and we've written it in the document. So now it becomes a contractual obligation. This is different than in construction contracts with the owner-contractor. There you have warranties and everything is 100%. Here, an architect can never do, because I've said this I think before to you guys, an architect can never give 100%, can never have perfect drawings. So the best you are required to do is perform in accordance to the standard of care, but now you're contractually obligated to perform into the standard of care. So you can have a breach of contract as opposed to just simply a tort. So what are the terms here? You want to perform your services, and remember they're professional services, consistent with professional skill and care ordinarily provided by architects, not extraordinarily, not the best architect, just ordinary architects, practicing in the same locality under the same circumstances. So I'm designing a toy factory in the Midwest in 2021. That's the same circumstances, the same type of project. You're not asked to be doing something that would be in California and what would have to be there, or in Europe, or you're not going to be the best architect. It doesn't have to have the parameters that maybe a hospital would have. It's just the ordinary architect in the same location at the same time for the same type of project. That's your standard of care. One thing you want to be careful, though, when you're an architect, if you're out and you get a contract from an owner, somewhere in that contract should be this provision. It's not an AIA, it'll be somewhere else, but the AIA is, for decades, has been Article 2.2. Make sure that they don't change language from ordinarily to best, or the best, or the extraordinary. So make sure that sometimes that they haven't risen or increased your standard of care. I have worked on, I think I told you guys this, but I can't remember. I've worked on some nuclear power plants. In those, the standard of care, we use the words exceptional or best, because we can't have a situation where you only have an ordinary nuclear architect. You have one thing that has to be the best because you want to have the best and safest project that's going to be built. Other things will put in the higher standard. But your AIA contract, because it's written by architects, because this is what's out there, ordinary standard care for the ordinary architect, locale, and similar project. Okay? 2.3 just says you need to talk to someone, representative that the architect can identify. This is another thing that referred back to when you had in the initial information. And 2.4, architects shall not engage in any activity or accept any employment that would appear to compromise the architect's professional judgment. This is kind of like you don't want to bring somebody in that's going to be maybe has relations with the contractor, so that, or maybe with the city, so that you can get them some things by. The owner needs to know that the architect's professional judgment is to themselves, to the owner, not to the contractor, not to a third party, not to somebody outside. And so this basically says, hey, if you're going to come here, you're going to work on my behalf, you're going to be professional judgment with respect to me as the owner, I'm the one retaining you, and I don't need these, unless I tell you, other interests that you have with other people that may be related to this project cannot affect or impact your professional judgment. I'll highlight them. As you might imagine, it's important that the architect has insurance for the project. So 2.5 identifies specific types of insurance that the architect should carry. And this is something that obviously the owner wants. So the first is commercial general liability, which we talked about before, and that's going to be if somebody slips and falls on the project, or not on the project, at the architect's offices or whatever. Commercial general liability is not typically, it will not cover at all any of the damages that may occur because the architect failed to perform. That's professional liability, which we'll get to in a minute. So the commercial general liability is slip and falls, somebody slips on the ice, somebody trips on your rug, those types of things. And as a result, for architects, it's very inexpensive because most of the time, the commercial general liability insurance is not triggered. Contractors are the exact opposite. Commercial general liability is the most important, but for the architect, you need to carry it, but it's really going to be not as relevant for the project. What other kind of insurance? You need to have auto insurance, because you're going to be driving to and from the project site. If somebody gets in a car accident in the course of their work, you need to have that insurance. 2.5.3, this talks about an umbrella. So sometimes maybe an umbrella or excess policy. Maybe you're carrying, as an architect, you're carrying a $1 million auto and a $1 million commercial general liability. Well, the owner may want to make sure that you have larger limits or greater coverages And so you would have an excess or an umbrella policy. And so this provision in the contract identifies what you need to have. Now, sometimes excess umbrellas aren't important, but this shows what may need to be required. And the owner's going to identify, for this project, you need to carry X in commercial general liability, Y in auto, and Z in umbrella. Workers' comp, that's going to be that's required in all states. There's workers' compensation statutes, and so anybody that works for the architect, if they're injured during the course of their work, they can recover workers' compensation insurance payouts. And so you, as the owner, want to make sure that that is available to keep everything protected. Employer's liability is a similar concept. That's if someone gets sick or injured, a disease or what have you during the course of their employment. So that's covered by insurance. And then 2.5.6, that's professional liability. This is the most important for the architect in performing its services. This, as you can see, covers negligent acts, errors or omissions, in the performance of the professional services. So 2.5.6 is the insurance that you, as the architect, need to carry. And if there's a design error, that wall falls down because of the design error, it's this policy, the professional liability policy, that pays out, and not the commercial general liability policy. Any questions on that? Okay. Talks about additional insured obligations. You don't need to worry much about that. It's just other parties that could be named on your commercial general liability and auto policy. And then certificates insurance. That's a sheet of paper that you present to the owner, and it says, it's got your name, it's got the insurance company's name, and then it identifies all the different types of insurance you're carrying and the value, the limits. $1 million policy, $2 million policy, $5 million umbrella, whatever those numbers are. And that shows, instead of handing to the owner a very detailed 75, 80-page insurance policy, you just give them the certificate, which is a 1 or 2 page, and it confirms to the owner, yes, before I started this project, I, as the architect, have the proper insurance in place, and you can see it. So it's kind of like a receipt in some ways. That's what the certificate of insurance are. So that is the complete list of your architect's obligations that you have to provide to the owner. Now we're going to get into Article 3, the scope of your services. So the first one you want to think here is the architect's basic services. And the basic services are what you're providing under the contract for that $150,000, the 10%, whatever it is. And it says they include usual and customary, as you remember when we listed the consultants, structural, mechanical, and electrical engineering services. So if you have specialty structures, if you have specialty electrical, whatever, that's not in the basic services. So if it's not usual and customary, you are going to add what's called supplemental or additional services, which we'll identify in Article 4. This is an important concept that you want to think about because it helps you to explain to the owner what they're getting for the price of your bid. If there are extraordinary or different elements that come up during the course of the conversation, because we know that usual and customary structural, mechanical, electrical are identified in their basic, it gives you the ability to say to the owner, okay, if you want specialty lighting, I'm going to have to hire a specialty low voltage lighting consultant. That's going to be a supplemental service or an additional service, depending on how it's identified. And that's going to be in addition to the $150,000. So you can use this as a discussion point to outline the price or the cost. And that will help the contractor understand, or the owner, how much they have to pay. Okay. And then, as it said, if they're not set forth here, they'll be set forth elsewhere. Now, part of your basic services, you need to coordinate your services with the services provided by the owner or the owner's consultants. So I think I've talked about in the past, use this example, like let's say you're designing for them a hotel, and the owner wants some specialty kitchen where they're going to have some star chef that's going to come in. They were able to bring in somebody from the one top chef or what have you, and so you want to have a showcase kitchen. Well, the owner may say, I'm working with like Stephanie Izard, she's here in Chicago. She is Girl on the Go and a couple other restaurants. I'm working with her. She wants to have the restaurant designed the way she wants it. She's got her own restaurant designers. So I, as the owner, will hire Stephanie and her team, and I'm going to tell the architect that. Well, the architect in designing its hotel or the overall space needs to coordinate based on this with my own specialty kitchen designer. So that's what this says, is that the architect shall coordinate. You have to work with each other. In addition, though, not only one thing is it shall coordinate, but it shall be able to rely on and not be responsible for the accurate completeness, blah, 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 of the information performed or furnished by the owner's consultants. So what this says is, okay, you're right. I know I'm not doing the kitchen, and I got to work with Stephanie and her team. But whatever they give me, it better be right, because I'm relying on them. So this puts an obligation back on the owner that says, if I hire someone, the information they're giving my architect better be correct, because the architect's relying on it. And if it's wrong, and the architect has additional costs, or the contractor has additional costs, it's going to be the owner's responsibility, because the architect here is allowed to rely on the accuracy of the owner's consultants. Last thing here, and this is part of how, if you remember, I talked about how the architect, these agreements are put together. There's a committee with representatives from architects and contractors and owners and all different parties. There's a push-pull that happens in these provisions. So the first part of this provision says the architect shall coordinate. So it's an obligation the architect needs to do. And the architect pulls back and says, wait a minute, yes, I coordinate, but I get to rely on them. So that's a win for the architect. But then the owner comes back with this last sentence and says, okay, that's fine, you can rely on it, but if you, as the architect, become aware of an error, if you see that my architect, my kitchen designer, screwed up, you need to inform the owner. You need to let me know, so I can go back to my kitchen designer. And what happens is, if the architect fails to give that information, if they become aware of an error by my kitchen designer, and they fail to do that, then the cost may go back on the architect. So this is a great provision in the agreement to show how there's a push and pull in negotiations. And I have not gone back and looked at the history, but my suspicion is this document, this provision, over the lifetime of it's been in there, kind of grew, because first it said they have been just the first sentence, and then maybe later the architects added the second, and then later over the 10 years the owner would add the third. But that's how you want to see, is that there's three shalls and how it's pushing and pulling both parties here. Okay. Next. So this talks about you need to. Remember we said there were some dates that we were going to put in the initial information? So 3.1.3 talks about the schedule. So as soon as practical after the agreement's been signed, the architect needs to provide a schedule for the performance of their services. We're going to get these drawings done by October 1st, and we're going to hit our own internal milestones. And then the architect also is going to put together this potential construction schedule. Because let's say I want to have the building completed by such and such a date. Well, I'm going to look, because the first entity I'm talking to is the architect. I'm going to look to the architect and say, not only do I want to hear how long it's going to take you to design it, but you're an expert. So I want you to tell me how long you think it's going to take to build it. So that's where it says the schedule shall include the expected or anticipated commencement of the construction when construction starts, and the substantial completion. When can I get in and start making my toys? And the architect has to do that. As you know, things can change, but at least the parties have it on writing, and at least some expectations are going to be established. And then said, once approved by the owner, the time limits established by the schedule shall not, except for reasonable cause, be exceeded by the architect or owner. So everybody has to comply with those dates. This paragraph is as simple as time is money. In every construction contract, the most important element, as far as I'm concerned over my 30 years plus years of practicing construction law, is that the most expensive thing in a construction project are delays. It causes people to accelerate and everything else. So this is one of the first points where it says, hey, if you give me a date, you got to meet it. And if you fail to meet the date, unless there's a reasonable cause, maybe the owner went from a 3-bedroom to a 4-bedroom house or what have you, neither the owner nor the architect can exceed those dates. And it's on both sides. Any questions on that? 3.14. The architect shall not be responsible for owner's directive or substitution or for the owner's acceptance of non-conforming work made or given without the architect's written approval. So what does that mean? So if we're out there and the project's being built and the contractor and the owner's there and the contractor shows something to the owner and the owner says, yeah, that's great, I accept it and I'm good with it. If the architect come back and says, well, wait a minute, that's not the way it was supposed to be designed, or that's not the way it was designed, the contractor can come back and say, well, hold on, the owner accepted it. Even though it's not designed this way, the owner accepted it. The owner cannot then look to the architect and say, well, you should have caught it. Basically, this is saying, while I'm your agent in some places, owner, while I'm trying to be loyal to you, owner, if you are out there giving a directive or a substitution or you're accepting non-conforming work, that's your problem, not mine. So this is a provision that was obviously entered into or added to this agreement at some point in time because some owner tried to put the blame on an architect. So we had to put it in writing and clarify, hey, I only speak for you so much, but if you're going to go out there and do things kind of separate from what I would handle it, it's your cost. And if the contractor needs to, wants a change order for it, or if you want them to rip it out and the contractor doesn't want to pay for it, well, you approved it, you gave that substitution, it's your dime, it's your money, Mr. Owner. 3.15. This is talking about communication with the government as far as whether you have permits or other types of things. And then here, the architect shall respond to all applicable design requirements imposed by the authorities and entities. So, I have a project going on right now up in Wisconsin, and they had the designs, they had dealt with the village, they had everything perfect, they thought it was good, and then they submitted the final designs, they signed the contract with the contractor, and lo and behold, the city came back and said, well, you need to do this with your soils, you need to do this with your footings, and there was a number of changes that the city wanted to have modified. Well, we looked to the architect and we said, you need to respond to these. You have to, because we've got to keep the project moving, and you have to do it on a timely basis. Now, the architect was paid for those because the architect didn't make a mistake. It's just the city was doing what the village was doing what the village was doing. But this is an obligation. It says if we do get something back from the governmental authorities, we've got to look to the architect to fix it, or fix the drawings to conform to that. And then 3.16 is the architect shall assist the owner in the filing of documents for government. That's because really here, the architect has much more knowledge base or they understand the system better. Like most owners, they're going to do one project. They're not going to know where the building department is and who to file it with and everything else. So here you want to have the architect assist the owner. And now we get into design phases. You guys may or may not know there are basically 5 traditional phases that an architect does in every construction project. There's schematic design phase, there's design development, there's construction documents, there's bidding and negotiation, and construction administration. So those 5 elements, those 5 provisions are in this contract, and we'll talk about each in more detail. But as an overall, schematic design is kind of when you're doing the preliminary stuff, you're setting up the program and everything else. Design development, now you're getting a little more detail. You have plans, you have sections, you have other things. So you actually, now the building is being fleshed out. Construction document phase is we've all locked in on what the design is. Now I'm going to actually create the drawings and the specifications from which the building will be built. And as far as your timing-wise, that takes about 40% of your design time. Maybe 15 for your design schematic, maybe 15 to 20 for your design development, 40% or so for your construction document, 5% for bidding and negotiation. That's just getting a contractor on board and doing those things. And then the remainder, 25% or whatever the number that's left over, is going to be construction administration, of the architect walking the site and making sure it's being built properly. So that's your 5 phases. And in here, the AIA is going to specifically go through what your obligations are. So first, under 321, the architect shall review the program and other information, and shall review laws, codes, and regulations applicable to the architect services. So you have the obligation to go out and say, what are the zoning areas here? What are the zoning codes? What are the rules as far as setbacks and height restrictions? Are there snow loads? Are there wind loads? Are there various other types? So you have the obligation, even though the owner wants to build this toy factory, you have the obligation to figure out what legally can be built there. That's under 321. 322. The architect shall prepare a preliminary evaluation of the owner's program, schedule, budget, etc., and then provide that information. So you're going to put together this overall evaluation, and you're going to say, I think, and you're going to notify the owner of any inconsistencies or other information. So I think you've come to me and you want me to build this toy factory for $10 million. That's your budget. This is where, if you look at it, it says budget for the cost of work. Remember, this is where you have that discussion. You understand, project owner, that this is only the cost of the work, your budget. Is that $10 million for just the construction, the materials and labor of the building, or does that include my price, the land, and everything else? That's part of your discussion there. But let's say you turn out and the owner wants it done in 16 months, and then they tell you all the detail that they want in there. Well, that's their schedule. That's their program. But if you can't do it, if it's impossible, if it's inconsistent with what's reality, if it doesn't work on the project site, if there's zoning issues, all these other things, this says the owner shall notify the architect shall notify the owner of any inconsistencies in that information. So this is where you are bringing your professional knowledge and services to the architect based on this provision, and you're obligated to do that. You can't come back later, 6 months into the project, and say, oh, did I forget to tell you there's no way we can do this in 16 months for $10 million? You have to tell them in the beginning, in the schematic design phase. And then the second part is there any other information? Well, we're going to do the basic services of structural, mechanical, and electrical, but you're going to need all these other specialty services. So that's what 322 is kind of giving you a roadmap of what you must or shall do with the owner to keep the project moving along. And then you're going to provide that preliminary evaluation, and the parties are going to come reach to an understanding. You're going to say, okay, this is what, maybe it's now an $11 million toy factory. Maybe we can't get it done in 16 months, we're going to do it in 21 months. Maybe we need to tweak this or tweak that. And that happens organically throughout the whole project, but this is in the preliminary investigation and preliminary evaluation, so the parties don't start on the wrong foot and the wrong understanding of what the program is. And then under 324, after you kind of get this understanding, you're going to do a preliminary design. You're going to do volumes, maybe you're going to do some sketches, maybe axonometrics, whatever it might be. Here's what I think the project is going to look like. So that's what, after you've gone through, you've done your evaluation, you had your understanding, 324 says, I'm going to present and prepare a preliminary design. And there, the owner is going to take a look at it, and if they approve the preliminary design, now you're going to prepare preliminary schematic design documents. So now you're going to get a little more detail. And this says, and it just gives it a kind of a little bit of a list. It says, consists of drawings and other documents including site plan, if appropriate, building plans, preliminary, sketches, sections, elevations, some other things. So now the building is starting to take shape. It's starting to have some form, so you can have a better dialogue or understanding, and because it allows you to start pricing out. Can we build this building now after what I've presented to the owner? Here's what it looks like on paper. Can we do it for the $11 million? I'll give you an example, like in real world, of what I was involved in a project where at this stage of the game, it was very important. So I worked for, my very first firm that I worked for as a lawyer, knew that I had an undergraduate degree in architecture, and they had been approached actually literally a month before they hired me by the building in which we worked to be relocated in the floors. And that had to do with the building had been originally built using asbestos for its fire insulation. And due to the asbestos, potentially people were getting sick and cancer and otherwise, they had to abate and remove the asbestos. So they were taking tenants. We were on floor 20. They had already abated floor 17. They moved us into floor 17. And they came to the owner, the company I work for, and they said, we'll hire an architect for you to design your new floor plan because it's going to be a wide open space. And they said, great. They asked me to be on the team. I'd only been working at the firm for literally like a month. And they said, we want your knowledge and information about here. And so I actually interviewed a number of the partners. What did you think you should have in a new space and everything else? What do you want? And we all came to what I believe was an agreement and an understanding. And then the owner of the building that was moving us, they came to us and they said, we're going to give you 2 architects, and I want you to tell them what you want. So we did that. We met with them and we kind of gave them this preliminary stuff. And the architects, both of them came back with their preliminary schematic design documents. They came back with this program, something in detail, based on the program that we provided. And what happened was neither architect was even remotely close to providing what the attorneys in the firm wanted. I had spent obviously much more time with them discussing what their wishes and desires were, as opposed to like a 1.5 to 2 hour meeting with each architect. And so I was seeing the drawings that the architects were providing. Good architects, but they just missed the boat. And so I actually had to go back to the management, because that's why they asked me to be on the team, and tell them, we have not gotten to a meeting of the minds of what the preliminary drawing should be. And so we need to either start with new architects or go back to the drawing board with these architects. 3251, this is the architect shall consider sustainable design alternatives. As I said, earlier versions didn't say, it would just say the architect will consider or may consider. Now it shall consider. And then if they're a more advanced sustainable design, it may be a supplemental services. So if you remember, the basic are structural, electrical, and mechanical. But if we now want something more under sustainable design, it's going to be a supplemental services. So this is a new addition to the previous versions. Same thing with 3252. Shall consider the value of alternative material, building systems, and equipment. Like, are we going to be doing, if it's going to be a green building, or what type of materials are we going to use? Or is there something that traditional construction we want to do, that we want to maybe use something a little bit differently? And how will that affect cost and program and schedule? Prior versions of the AIA was you will consider it, but it wasn't an obligation. Here you need to. You need to have a discussion with the owner about these either sustainable designs or building alternatives. And when I look at this, what I think the reason why this is because this gets the architect in the position of, I won't say thinking outside of the box because it's within the 4 corners of the document, but thinking more, I can bring more to the table to this owner. The owner, if you want to think about owners most of the time know about 10% of what they really want. And your job is to hear them and fill in the other 90%. And if you can fill in that 90% by giving them more things that you can do for them, A, it helps the project become a nicer project. B, if it's like sustainable, it may help society. And C, for you as a business, you may generate more revenue. It's not $150,000 for that house. It's now $150,000 for that house plus additional design fees for A, B, and C. Or it's not $1 million fee for that $11 million toy factory. It's $1,250,000 because you're going to add additional services. So these 2 provisions help in everybody. It helps the client, it helps society, it helps your business, because now you shall be required to think about these alternatives. So that's something important. So after you've gone through, you've got to the program, you've considered the additional materials, you've started to do the sketches and everything else, at this point in the process, you now need to give an estimate of the cost of the work. Okay? And it says, shall submit the owner an estimate of the cost of the work in accordance with 6.3. So I needed to add in here 6.1 and 6.3 so you understand. So here, the cost of work shall be the total cost of the owner to construct all elements of the project designed or specified by the architect and shall include the contractor's general conditions, cost, overhead, and profit. As you can see, nowhere in there does it talk about payment to the architect. In fact, later in this provision it says the cost of work does not include compensation to the architect, cost of land, etc., etc. So when you're submitting your estimate under your obligation under 3.2.6 of the cost of the work, it's going to be as defined in 6.1 and then in 6.3. And it tells in 6.3, when you are preparing your estimate, you need to include the following information. So this is a roadmap. So very beginning of your services here, you're sketching, you're designing, you're talking, you're creating, you got the program, but you got to make sure that you're within that $1 million budget for the house or the $11 million budget for the toy factory, whatever it might be. And you have to build that estimate to the cost of the work. And you use 6.1 and 6.3 to tell you how to do it. It also tells the owner how you're going to do it. So this is where you have that discussion with the owner when they say, oh, well, my budget $1 million is for everything. And you say, well, look, let's just make sure you understand in the contract that's not what the cost of the work is. So what's your cost of the work budget? Tell me what that is, owner. What's that necessarily estimated budget? And say the owner says, well, that's $850 or $700 or whatever it might be for that house. So this helps you have that discussion by looking to the provisions of the contract. Any questions on that? Okay. And then you shall, under 3727, you shall submit your schematic design to the owner and request the owner's approval. If you think about these 5 phases, you want to make sure that you get the owner's approval before you go from phase 1 to phase 2. And so this requires that you need to submit it and you need to request approval. I have had many a case where the architect has submitted the schematic design, and they're under a schedule to meet dates, and they start with design development right away, and maybe the owner sits on the schematic for a while, maybe it's a month later, 3 weeks, whatever it is, and then they come back and they say, I don't like this, I need to change this, I need to change that. Well, you're already 3 weeks into doing design development, and if they haven't gotten the approval, you can't go back and say to the owner, well, I've already spent time, I've got draftsmen working on it, I got my junior designers working on trying to take those schematic designs to design development, and now you're changing the program. Well, that's because you went ahead too fast. So it's important to recognize, and what you'll find at the end of each one of these phases is this very same sentence. You submit and you need approval. And that's important. And sometimes you want to even have approval in writing to make sure that you get paid for your work in the next phase. The last thing you need is an owner to say, I'm not paying you for phase 2 because I didn't approve phase 1 yet. Then you're kind of stuck. Okay. So now we go to phase 2, design development. So, based on the owner's approval, so there it goes right into it. If you've approved the design development, the architect shall prepare, the schematic design. Based on that approval, the architect shall prepare design development documents for the owner's approval. And here it says, what is in that? Well, you can look, this list is a little bit longer than what was in schematic designs. So it consists of drawings and other documents, including plans, sections, elevations, typical construction details, layouts to fix the size and description, character, and so forth. So, and now you're even getting into the structural, mechanical, and electrical systems. So now instead of preliminary plans and sections and elevations, it's actual plans. So now we're getting into the true design development. And this is where the building really starts to take a look at what it's going to be like. This is not as, like I said, this may be 20% of your time, but this is now where you're taking that program and you're really starting to show something to the owner to understand what the project's going to look like. 332, you have to update the estimate of the cost of the work. So after you've created these design developments, now you got to go through and run that math again. If my budget is $1 million for the house, and that's for the cost of the work, that's what we know, we're on the same page for that. As I started to refine my drawings, am I still within that $1 million? So I got to update that estimate. And then you need to submit to that the design developments to the owner. And if there are adjustments to the cost of the work, you have to get their approval. So at the end of design development, let's say you submitted at the end of SD, schematic design phase, you submitted your preliminary schematic designs, everything looked good, and you said we're within $1 million budget. Great. Then over the next month, 2 months, 3 months, whatever it is, you and the owner are working more, you're tweaking, you're detailing, and it turns out, now my estimate's $1.1 million instead of $1 million. Mr. Owner, your house has gone up a little bit. You have to submit that. You have to let them know. And the owner has the right at that point to say, well, wait a minute, you knew my budget was $1 million. Now you're telling me the estimate's 1.1. And so in that instance, the owner can either approve it and identify or modify its budget. If you remember way back when, it says if there's a change in the initial information, which includes the budget, then the owner shall adjust its own budget. So if it's $1.1 million, the owner has to recognize that their budget has to go up to $1.1 million. Or the owner can say to the architect, no, my budget's still $1 million. You need to go back and fix the design development drawings, and I'm not going to pay you more for that because we've already determined what our cost is and what the fee is. And you got to get it back within $1 million. You got to take out whatever it is on the backyard deck or whatever you might have included that we didn't have enough information, but it caused it to blow the budget. So that's what happens here under 3.3.3. Any questions on design development? Pretty simple. It's pretty easy. There's more in schematic design than design development, but it's the same type of process. Here's what they are. Here's my estimate. Here's the delivery. Phase. Again, it starts out based on the approval of the design development. Now you got to prepare the construction documents. Now we go to construction documents. Drawings and specifications here are capitalized. So that means that those are a defined term in the document. In fact, they are a defined term for all the documents. When the contractor enters into its owner-contractor agreement, they're also going to have capital D, capital S. And it's defined as specifically those documents for which the contractor can build the project. So this is where now you understand a little bit more of how a defined term is relevant. So basically, if the drawings that were provided at design development were given to the contractor, he can't build from that. But the drawings and specifications provided to the contractor are something that can be built from. And so that's why this phase 3. This construction document phase, the third phase of the 5, why it takes so much longer, 40% of your time, because now you have to put in all the quality level performance criteria, material systems, and other things required for the construction of the work. So it's all the information necessary to build the project. Other part here, and if I remember, as I said, well, this is the owner-architect agreement. From time to time, it will reference other parties and obligations of the other parties. So here it says, the last part says, the owner and the architect acknowledge that in order to perform the work, contractor will provide additional information. So now it says, I'm telling the architect and the owner, at some point in the future, the contractor must provide. And those are shop drawings, product data, sample, and other things, which the architect shall review in accordance with 364, which we'll get to in a little bit. But this shows you how these suite of documents work together and interrelate as far as how the project is designed and ultimately built, and that they need each other, the contract. 3.4.2, you need to bring in design requirements of government authorities. So, as I said, sometimes you're in the process of putting these drawings together, and you get information and feedback from the governmental building department or what have you in the beginning of the construction document phase, sometimes in the middle, sometimes at the end. Like I said, this project I had up in Wisconsin, they had to do a whole bunch of revisions based on the things that the village had said after they had gotten everything ready, after they signed the contract, and the contractor actually started to break ground, and then they had to come in and kind of stop everything to fix what the city or the village wanted. 3.4.3. Oh, one other thing. The term here, this term construction documents. So those are also a term that's used as kind of a conglomerate of all the things that the contractor is going to use to build it. So the drawings and specifications on this page are included as a subset of the construction documents. Okay? So they may have, you have the drawing specifications, but they may also include other items that the contractor may need, codes and other things that ultimately create what's called, in capitalized, construction documents. On the next slide here, so it says, the architect shall incorporate the government authorities into the construction documents. So they may be part of the design, the drawings and specifications, or there may be something else that the village needs. They could be the permits. They could be whatever it might be that ultimately are the construction documents used for building the project. And then during the development of those construction documents, as the architect's developing these in this phase, the architect shall assist the owner in the development and preparation of, and there's a list of things here. So bidding and proposal forms, so if you want to go out to bid, the agreement between the contractor, general conditions, so all the things. So like, as I said, there's these other AIA forms, the owner contract agreement. You may be, as the architect, may be in the position or place to help the owner put together and ultimately negotiate the construction contract. And that's why during this class we actually talk about the owner contractor agreement, even though you're architects, so you guys understand when you get asked by the owner, help me with my contract with my contractor, you're obligated under 3.4.3 to do that, and you'll understand how to do it based on hopefully what we learned today or over the semester, and then just looking at the documents. Again, the architect shall prepare an estimate for the cost of the work, just like everything else. You've got to update it. And then you submit those construction documents to the owner, advise of any adjustments, and take any action required under 6.5, which we'll cover later, and then look for approval. So in this instance, now here are the drawings and specifications and the construction documents you need to use, owner, to go out and get that contractor so she can build the building. And we want to make sure you're good with this. We're going to sign off of it, and everybody's okay. And that's what the end of this phase of the construction document phase. Okay?
Section 3.5 is about the procurement phase, in which the architect assists the owner in establishing a list of prospective contractors. After the owner approves the construction documents, just like every other phase, the architect assists the owner in obtaining either competitive bids or negotiated proposals. They also assist the owner with confirming responsiveness of bids or proposals, determining the successful bid or proposal, and, if any, award and prepare contracts for construction. So when you're looking for a contractor, you basically have two options: competitive bidding or negotiated proposals. Both of those are part of the procurement phase. In competitive bidding, the bidding documents shall consist of bidding requirements and the proposed contract documents, such as the drawings and the specifications that you produce during the construction document phase. The architect shall assist the owner in bidding the project by 1. Facilitating the distribution of bidding documents to prospective bidders. 2. Organizing and conducting a pre-bid conference for prospective bidders. 3. Preparing responses to questions from prospective bidders and providing clarifications and interpretations of the bidding documents to the prospective bidders in the form of an addenda. And 4. Organizing and conducting the opening of the bids and subsequently documenting and distributing the bidding results as directed by the owner. If the bidding documents permit substitutions, upon the owner's written authorization, the architect shall, as an additional service, consider requests for substitutions, and shall prepare and distribute addenda identifying approved substitutions to all prospective bidders. Now, negotiated proposals are fairly similar to competitive bidding. In negotiated proposals, proposal documents shall consist of proposal requirements and proposed contract documents, as opposed to bidding requirements and proposed contract documents. The architect shall assist the owner in obtaining proposals by 1. Facilitation and the distribution of proposal documents for distribution to prospective contractors and requesting their return upon completion of the negotiation process. 2. Organizing and participating in selection interviews with prospective contractors. 3. Preparing responses to questions from prospective contractors and providing clarifications and interpretations of the proposal documents to the prospective contractors in the form of an addenda. And 4. Participating in negotiations with prospective contractors and subsequently preparing a summary report of the negotiation results as directed by the owner. Now, if the proposal documents permit substitutions, upon the owner's written authorization, the architect shall, as an additional service, consider requests for substitutions, and shall prepare and distribute addenda identifying approved substitutions to all prospective contractors. Once you've completed procurement and found the contractor, you're ready for the construction phase. The architect shall provide administration of the contract between the owner and the contractor as set forth below and in AIA document A201-2017, General Conditions of the Contract for Construction. If the owner and contractor modify AIA document A201-2017, those modifications shall not affect the architect's services under this agreement unless the owner and the architect amend this agreement. The architect shall advise and consult with the owner during the construction phase services. The architect shall have authority to act on behalf of the owner only to the extent provided in this agreement. The architect shall not have control over, charge of, or responsibility for the construction means, methods, techniques, sequences, or procedures, or for safety precautions and programs in connection with the work, nor shall the architect be responsible for the contractor's failure to perform the work in accordance with the requirements of the contract documents. The architect shall be responsible for the architect's negligent acts or omissions, but shall not have control over or charge of, and shall not be responsible for, acts or omissions of the contractor or of any other persons or entities performing portions of the work. Now, subject to Section 4.2 and except as provided in Section 3.6.6.5, the architect's responsibility to provide construction phase services commences with the award of the contract for construction and terminates on the date the architect issues the final certificate for payment. During the construction phase, the architect is responsible for evaluating the work on the site. The architect shall visit the site at intervals appropriate to the stage of construction or as otherwise required in Section 4.2.3 to become generally familiar with the progress and quality of the portion of the work completed, and to determine in general if the work observed is being performed in a manner indicating that the work, when fully completed, will be in accordance with the contract documents. However, the architect shall not be required to make exhaustive or continuous on-site inspections to check the quality or quantity of the work. On the basis of the site visits, the architect shall keep the owner reasonably informed about the progress and quality of the portion of the work completed, and promptly report to the owner, 1. known deviations from the contract documents, 2. known deviations from the most recent construction schedule submitted by the contractor, and 3. defects and deficiencies observed in the work. The architect does have the authority to reject work that does not conform to the contract documents. Whenever the architect considers it necessary or advisable, the architect shall have the authority to require inspection or testing of the work in accordance with the provisions of the contract documents, whether or not the work is fabricated, installed, or completed. However, neither this authority of the architect nor a decision made in good faith either to exercise or not to exercise such authority shall give rise to a duty or responsibility of the architect to the contractor, subcontractors, suppliers, their agents or employees, or other persons or entities performing portions of the work. The architect shall interpret and decide matters concerning performance under and requirements of the contract documents on written request of either the owner or contractor. The architect's response to such requests shall be made in writing within any time limits agreed upon or otherwise with reasonable promptness. Interpretations and decisions of the architect shall be consistent with the intent of and reasonably inferable from the contract documents and shall be in writing or in the form of drawings. When making such interpretations and decisions, the architect shall endeavor to secure faithful performance by both owner and contractor, shall not show partiality to either, and shall not be liable for results of interpretations or decisions rendered in good faith. The architect's decisions on matters relating to aesthetic effect shall be final if consistent with the intent expressed in the contract documents, unless the owner and contractor designate another person to serve as an initial decision maker, as that term is defined in AIA document A201. The architect shall render initial decisions on claims between the owner and contractor as provided in the contract documents. During the construction phase, the contractor will submit for payment, and the architect will submit certificates for payment to the owner. The architect shall review and certify amounts due the contractor and shall issue certificates in such amounts. The architect's certification of payment shall constitute a representation to the owner based on the architect's evaluation of the work as provided in section 3.6.2 and on the data comprising the contractor's application for payment that, to the best of the architect's knowledge, information, and belief, the work has progressed to the point indicated, the quality of the work is in accordance with the contract documents, and the contractor is entitled to payment in the amount certified. The foregoing representations are subject to an evaluation of the work for conformance with the contract documents upon substantial completion, to results of subsequent tests and inspections, correction of minor deviations from the contract documents prior to completion, and specific qualifications expressed by the architect. The issuance of a certificate for payment shall not be a representation that the architect has made exhaustive or continuous on-site inspections to check the quality or quantity of the work, has not reviewed construction means, methods, techniques, sequences, or procedures, has not reviewed copies of requisitions received from subcontractors and suppliers, and other data requested by the owner to substantiate the contractor's right to payment, or ascertained how or for what purpose the contractor has used money previously paid on account of the contract sum.
They have to review every single material that's going into the project, and the answer is no. There are going to be certain things that your drawings and specifications will require approval of the submittal. There will be certain times when there's a substitution. So there's going to be kind of an understanding of industry practice and standard. And then for more complex projects, you're going to have a very detailed submittal schedule. And it'll say electrical, and it'll have all the things that the contractor will need to do the submittal. And it will have, for all those electrical items, it's going to have a date when the drawings are issued, and then it'll have a date of when the contractor needs to give you the submittal, and then there'll be a checkbox of when the architect needs to get back, and there may be, you may reject it because the submittal's improper, and then they'll have all that information and have, it's called a DOR submittal schedule, so it'll be division of responsibility, the DOR, and it shows who does what, who does when and what. So sometimes it'll be very detailed. Sometimes, like, for example, we did an expansion of my kitchen a couple years ago. So it was just a very small little 150 square foot expansion of the kitchen, very little. But we had some tile for the floor, and we had some crown molding that had to be looked at. And so we didn't have a submittal schedule, but at a point in time the contractor said, here's the tiles we're going to use, are you okay with this? That's what we did, and we showed them to the architect as well. So it just kind of depends. Okay? Does that answer your question? Okay, great. So it continues on. Contractor submittal such as shop drawings. So sometimes you're going to put in your drawings a series of columns and the beam, but you're not going to show how those connections, those bolt connections go. So the contractor and its steel subcontractors can go out and create shop drawings, or how the electrical is going to work, or how the plumbing, mechanical. Those are shop drawings. And they're going to do the more detailed drawings of what it looks like. So that's a shop drawing. Product data and product samples, so they may show you the bricks, or they may show you the history of the data, like I said, the testing of the concrete or whatever. And those are given to you, but only for limited purposes, and this is what the architect's limited purpose is, of checking for conformance with the information given in the design concept expressed in the contract documents. What this means is you are not checking the math. When they send you shop drawings and they have a bolt diagram of where the bolts need to go to connect the column to the beam, you're going to look at it to make sure that the column and beam has a proper connection. You are not going to check to see if they did the proper mathematics to see if the size of the beam and the web and the flange is sufficient, or that the bolt diagram was in the proper location. That's the responsibility of the specialty steel contractor doing that. So you're looking at it for limited purposes of checking for conformance with the information given and the design concepts. Now sometimes the information given may require something very specific. And so in that instance, because your specification said I need it to be within parameter A and B, then you may need to burrow in a little bit more. But generally what this provision says is you're not checking their math. You're not checking the accuracy and completeness of other information, such as dimensions, qualities, installation, and performance equipping your systems. If you say you needed a pump that needed to move X thousands of gallons per hour, and the contractor goes back and gives you a spec sheet on that pump and says, this is the product data of this pump, it says it should do that, that's all you need to do. You're not going to go in and look at the testings and everything else. You should be able to rely on those submittals as long as it's done timely. And so there's certain obligations. While the contractor's not designing, they are still satisfying your design requirements. Does that make sense? Okay, the last part here is kind of a repeat. It says, your review shall not constitute any approval of safety, means, methods, techniques. So if they say this is how they're going to do the bolt diagram, it looks like it's supposed to be, but I'm not saying it's safe, and I'm not saying that the bolt diagram's right because I'm not telling you how to crank those bolts down. I'm just saying it looks like it should be for the design concept of the drawings. It's not an approval of the assembly. So you kind of have some more get-out-of-jail-free cards here. I'll give you an example. Many, many years ago, there was a collapse out at Rosemont of the concert hall or whatever, and it was a huge deal. And the architect had gone out and done inspections, and the architect got sued because they felt that there was design errors. Well, it turned out there weren't design errors, and in fact the contractor had done improper shop drawings, and as a result of the shop drawings, the way it was built created a structural instability. Well, the architect reviewed those shop drawings and said they looked right. And so the owner tried to the damage, tried to bring the claim against the architect, and the architect looked back to this provision and said, I reviewed it, but I'm not there to check the math. My design was correct. They gave me the drawings. I reviewed the submittals. They looked like they were consistent, and we moved forward. The failure was as a result of the improper shop drawings and the improper structure of it and how they installed it. Therefore, I'm not responsible. So this is an important provision kind of to potentially get out of liability in cases. Now, 3.6.4.3, this talks about if the contract documents specifically require a contractor to provide professional design services or certifications, you shall specify the appropriate performance and design criteria that such services must satisfy. So what does this mean? Well, there are some times in construction projects where a contractor actually does need to hire its own engineer. That is where it's most common in construction projects, although there's many different instances. And they call this design delegation. If there's a fire protection system, the architect will not design the fire protection system. They're going to say it's a wet system or a dry system and it needs to meet with code, and they're going to make sure there's room in their drawings for the pipes to run, but they are not going to design it. The contractor, when they hire the fire protection system installer, will make sure that fire protection system installer has their own engineers to design. So all the architect has to do is provide design criteria. A wet system, over 10,000 square feet, in a factory warehouse, in accordance with the code in Illinois. Something to that. That's the design criteria. Everything else, the contractor has to provide that. Other areas are curtain walls will require, the contractor will do that. A lot of this has to do with proprietary things, like the fire protection system and curtain walls, they're proprietary intellectual property, so the contractor and their subs will handle that. Shoring and bracing, where you're digging holes and whether you want to make sure the land doesn't move, that's another place where there's going to be the contractor's responsible for the design side. So, as I said, generally in the construction contract, they're going to say, I'm not responsible for design, except for this one area where there's maybe some specifics where the architect says you have to bring the design professional in. Okay? And the last part of this provision says, kind of like the kitchen designer or the owner and the architect, when the architect could rely on the kitchen designers from the owner's side, here, if the contractor is bringing in its own design professional, the architect shall be entitled to rely upon the accuracy of those certifications from the contractor's design professional. So if the curtain wall designer says this is the way the building needs to be, the structure of the building needs to be to support my curtain wall, and here's my numbers, and that curtain wall designer provides that information, you as the architect can rely on that, even though it's coming from the contractor. Okay? 3.6.4.4, the architect shall review and respond to requests for information about contract documents. That's called an RFI, request for information. Sometimes what's going to happen is the contractor is going to review your drawings and maybe not understand everything. It may not be as clear because you didn't give them 100%. So they're going to issue an RFI. And you have to respond to those. You have to do it promptly, and you have to give them in writing. So they send you something in writing on an RFI form, you respond. It helps clarify, well, how's that soffit going to work? How does that corner detail work? What are we doing with this? Because the drawings don't have 100%. It didn't mean your drawings are wrong. It just means that there needs to be some more clarity to help the contractor build it properly. So that's what you have to do under 3.6.4.4. Changes. As I said, things happen on projects, and projects change. So what do you do with that? And what's your responsibility? So here, under 3.6.5.1, the architect may order minor changes in the work that are consistent with the intent of the contract documents that don't involve an adjustment in the contract sum or the contract time. If you want to change the color of the paint from blue to white, you can do that. If you want to move something around, as long as it doesn't change the time or the price, you can do that. And that's a minor change. But if things get more detailed, then you have to go through what's called a change order, or a constructive change directive. So those have to be in writing, and they have a little bit more process to go through. But you can do minor changes in the work. Okay? 366. Now we get to project completion. This is still all part of your construction administration phase, just so you know. You shall conduct inspections at the final completion, either at substantial completion or final completion. You're obligated to issue certificates of substantial completion. If it looks like the building is fit for its intended use and purposes, you issue that certificate. You're going to forward to the owner any warranties or other documents that's been collected, so the pumps and the air conditioners and anything that has a warranty. You're going to gather that from the contractor. You're going to forward that to the owner so they have their warranties. And then you ultimately issue a final certificate of payment that says, yes, everything's done to the best of my knowledge. It complies with the contract documents, and you, Mrs. Owner or Ms. Owner, can pay out to the contractor because, to my understanding and belief, everything's complete. And that's after punch list and everything else is done. Okay? 36.6.2. The architect's inspection shall be conducted with the owner to check with conformance of the work and the requirements of the contract documents in order to verify the accuracy and completeness of the list submitted by the contractor for the work to be completed or corrected. This is a punch list concept. So what happens is you walk the project at substantial completion, and you want to issue the certificate for substantial completion and the payment associated with that. There's other things that trigger legally at that point in time. We'll talk about that more with the contractor, but it's important for that. At that period of time, when you're walking around, you're going to create what's called a punch list. The punch list is going to say, there was nicks on the wall that needs to be repainted. There's a chip in that floor tile. This cabinet's a little bit crooked. Nothing's so major that the building can't be used for its intended purposes, but it's not proper, it's not finished, it's not complete. So you create this punch list. And then you use that through the inspection. And then you work with the owner and the contractor under 36.6.2 to make sure that that punch list is accurate and that the contractor is accurate, and then that ultimately the contractor fixes it. They do that painting, they fix the chip tile, they straighten out the cabinet. So that's what 3662. 3664 is just some more paperwork you need to send. 3.6.6.5. So, upon the request of the owner and prior to the expiration of the 1-year date of substantial completion, because that's like your warranty period, a lot of warranties are 1 year, the architect shall, without additional compensation, conduct a meeting to order to review the facility operations performance. Basically what this says is, the owner gets one last chance for you to walk the site within a year after its project is done and make sure that the building is what it should have been. So you're helping them with a warranty review, you're helping them make sure, maybe I missed a crooked cabinet, let's do that one more walkthrough. And while, if you remember, there was a provision that said, your construction phase services end at certificate of final payment, which if you remember in the previous slide, or 2 slides before you just issued, that issue of final payment, you still contractually have to come back for one more meeting to walk the site and make sure that everything's as it should be. The amount of times an architect does this is very rare, but it's in the contract that you can do that and you don't get paid for it. So that's that one last time. Okay, that's all the work that you guys need to do. Those are your 5 phases of construction that you need to do as the architect. Now we're going to go through, in the last 10 or 12 minutes, the additional services and supplemental services. This shouldn't take too long, okay? Any questions on the construction, your obligations under the 5 phases? All right. So there are 2 types of services that are performed. You have supplemental services and you have additional services. And what's the difference between the 2? Supplemental services, they say, are listed below, and I have this in parentheses as a chart in 4.12. In the AIA documents, there's this long chart of all these different types of things. Like you can do advanced design, you can do landscaping services, you can do civil engineering, you can do lead work, you can do high voltage lighting, there's a whole bunch of different things. Each one of those is supplemental, and for any one that you do, you get paid additional money because it's not part of the basic services. If you remember, basic is structural, electrical, mechanical. Anything other than those three are supplemental services. And so what the AIA document here is under this chart is they create this kind of shopping list. And it's a good thing for you to discuss with your clients. Let's go sit down and go through the shopping list and let's talk about what those supplemental services are. Let's go through and see if you want any of those. Do you want me to do landscape architecture for this? Do you want me to do LEED or other type of green sustainability reviews? Here's what it would be. Here's what it would cost. It's in addition to what I've quoted you for the $150,000 for that house to do these additional things. So that's good for you. It helps you discuss more business things, and those are called supplemental services. Additional services are, I'm supposed to do structural work, but now you want me to do more structural work that wasn't anticipated in my original fee. So its additional services are the basics, but you're doing more than what was anticipated in the basics of those three, including four: architectural, structural, mechanical, and electrical. So that's the difference. Supplemental services are the architect's responsibilities provided below, and there's some things that are in the chart. This section 4.11, both of those, that's the chart. Some are the owner's responsibility. Obviously, if you're going to be doing the owners, they're not going to pay you anything more for that. But sometimes there's stuff that has to happen that the owner needs to provide you information or whether to allow you to do some supplemental services. Architect's additional services, as I said, is any additional services provided in accordance with this section, and you get paid for that. In pursuant to 11.3, that's your compensation section of this agreement. So an additional service, as I said, is more of the basic, but you're doing in addition to it. And it could be more sophisticated. It could be, I'm doing electrical. We thought we were going to do straight electrical, but now I need to do high voltage electrical. That's still electrical. It's in addition to what the basic services are. I get paid for it, so I'm going to perform it. Okay? If there's the need to perform additional services, because a lot of times the owner doesn't, it's not necessarily a scope change, just the architect realizes they need it. The architect shall notify with reasonable promptness and explain why there needs to be additional services and get approval and authorization so you can be getting paid for that. So, it could be, they say, and they're not supposed to perform unless you get that written authorization. So you can't just go ahead and do it until you get that. It could be the services, those additional services, could maybe because of change in initial information. Well, we went from a 3-bedroom to a 4-bedroom, but I still needed to be in the footprint, so I had to add more structural steel to carry that. So the initial information changed. That was a material change, so that caused some complexity issues, so that's why I need additional services on structural. There could be changes in laws or codes. That could be a reason. The city passed some new laws. You have to do that. There could be interruptions by the county. Maybe there was a delay. Or maybe there was a weather delay, or maybe there was something else, something that was contrary to the instruments of services. Maybe the owner didn't do their time. They didn't render their own decisions. Maybe the owner didn't make decisions on what needed to go here. So as a result, I had to go out and design a different style or a different issue because the material wasn't available. Maybe I had to do digital models because of the way the contractor was so complex, what needs to be built. So all these, this is a list. Alternative bid proposals. This is a list that goes all the way through the next slide here of additional reasons why of other reasons why there would be additional services. I have to go to public meetings. I have to make presentations. That was not discussed in the original basic services. I may have to go to a dispute resolution proceeding. I have to go get a deposition. That wasn't in the basic. Valuations of identities providing bids. Maybe I was going to just help you put the contract together, but now you want me to do an in-depth review of all the information of the bidders. That's an additional service. Replacement of work, or if I'm going to be an additional decision maker, or there's some other initial decision maker, you bring in another third party to handle those claims, then possibly I get paid for those services. So those are all additional services that are part of basic, but you have to get approval for them. But these are the reasons why they would come up. Any questions on that? So this thing, the additional services, you got to get them. Oh wait, did I go backwards? Hold on a second here. These duplicative. 3, 2, 1, 2. No, I'm sorry. Okay, so to avoid delay in the construction phase, so that those things may come up earlier, there may be additional services to keep things moving along. This is so there's no delay in the construction phase, and again, you have to give notice of that. So why would the previous list of why would come up is not related to the construction phase. These are other reasons why there may be additional services. So you have to review a submittal out of sequence. Remember there was that submittal schedule I talked about. Well, maybe you have to review more than 3 or 4. They're out of sequence. That's one reason. More RFIs than the contractor was supposed to do. They didn't do their job. They didn't do proper. They asked for an RFI. They shouldn't. Change orders, constructive change directors. So these are a list of there's a whole bunch, many more claims that you were supposed to look at than you thought under your basic services. All of these would come up during the construction phase that would require you to do additional services and entitle you to more fees. 4.2.3, as I said, sometimes this talks about how often you're supposed to be doing something on the project. So remember, I talked about like site visits. Maybe it's once a week, month to month, or maybe it's specifically defined in the contract. 4.2.3 is where it defines. So submittals, this would say how many reviews based on your basic fee are you going to review a shop drawing? Is it I'm only going to review one, and if I reject it and then they come back with the second one, I get to charge you for the second review. Sometimes, a lot of times this is 2 reviews, but you can negotiate what the value is. How many site visits to the project during construction? Once a week, once a month, 5 times total. That's what you're going to put in. How many times do you inspect during the course of the project, and how many times do you inspect for final completion? It's important to fill these things out because then the parties understand this is the value or the cost of that you've built into your fee for the basic services. And if any one of these 4 line items you exceed, well, then you can charge more money for those. Okay? Except for services required under 3665, which was earlier under the completion of the construction work. This says construction phase services provided more than 60 days after substantial completion or the initial substantial completion date identified in the agreement, you get additional costs. So if you remember, it said your construction phase services end no matter what at final completion, at the final payment. But let's say between substantial completion and final completion, it takes forever for the contractor to finish out the punch list. If it's more than 60 days, you get to be paid for those as additional services. So this gives you more chances to get paid for your work. You shouldn't have a project that takes more than 60 days to punch out, but sometimes it does, and you should be paid for that work. And then 425 talks about if you haven't completed the project within a certain period of time, then you can be compensated after that for additional services. So sometimes the project is delayed. You start working on it, the owner says, put it on hold, I got to get financing, and then it's delayed for 6 months or a year. When they come back to you, you may be able to get an increase in price because that's the cost based on the delay. This is the owner. What are the obligations that the owner has to have when they start out for the projects? As you might suspect, it's significantly less than what the architect has to do, but the owner still is required to provide some information. So, starting off with Article 5.1, the owner shall provide information in a timely manner regarding requirements for information on limitations on the projects. Pretty simple. One of the things that I think I talked about a little bit in contracts is sometimes the most basic, simple concepts, like, well, of course they got to provide information. But you want to have that in there. You want to make sure that everybody understands what it is. And that way, you can't have a discussion later on where someone says, but that was so simple, so basic, of course you're supposed to provide the information timely. How can you not know that that's a requirement? Well, you could get in a squabble about that. You can get in a fight. Somebody could say, well, what is timely? Or why did you need this? Or you didn't tell me what I had to have. And so you want to write this down. So sometimes things are as simple and black and white as this one is. Just as an example, so I was on the phone with one of my clients yesterday, and they have they're an owner, and we have a contract on a large project with a construction contractor. They're in the process of building a facility, and in the contract is what's called an incentive clause. And so at certain points during the course of the project, the parties they have 5 criteria. It's cost, safety, performance, management, blanking on the 5th one. And there's a set of parameters that are spelled out as to how the contractor can earn a bonus if they have met the certain criteria for the incentives. And that's an exhibit to the contract. So there was a meeting last week of all the principals. There was the senior management of my client, and there was the senior management of the contractor. I wasn't at the meeting, and the contractor showed up with these forms. And he's like, okay, I'm going to pass these forms out. You guys grade us, and then by the end of the meeting, we'll figure out what our incentive bonus is. Luckily, there was enough people on my client's side to have kind of the understanding to say, wait. We got to make sure we're following the process. The process was very simple, but we got it. Well, I explained to them yesterday. I go, guys, we can't just do things ad hoc. We got to follow the rules of the contract. And so we have a rule of how you go and figure out the 5 criteria and how you do that grading. And so it's as simple as, I always call it the rules to monopoly, but you want to follow those rules to monopoly. And so that's the issue here, is that the owner is required to, in a timely manner, to keep the project moving forward, to give whatever requirements or limitations that they have, and they have to provide it in a written program and otherwise. So that's the basic gist of that, and you'll see that in all contracts. Well, you'll see that in all AIA contracts. There's a lot of contracts you'll see they won't have this information, but this is something that you want to make sure you do as an owner. And if you're the architect on the other side, and the owner has not given you stuff timely, well, then you can write a letter back and says, I can't move forward. I don't have the information. So if the project's delayed, it's your fault, not mine, effectively. 5.2. So we talked about this last week a little bit about the concept of budget versus cost of the work. And this is again outlining. So the owners required, one of their requirements, and that was from Article 1, the initial information, is they got to establish a budget. And then the owner needs to update that budget if there's changes that the owner agrees to. So you can't have a budget that says, I want $1 million house, then they come to you and tell you that it's from a 3-bedroom, 3-bath to a 4-bedroom, 3-bath. The owner still has to recognize that they need to update. So we have an obligation. The owner shall update that budget. And if the owner significantly increases or decreases the budget for the cost of the work, the owner shall notify the architect. So these are things that they have to do and let the architect know. And it requires communication back and forth between the parties. Article 5.3, you got to identify an authorized representative. That's just the point person. And the reason for that is you don't want to have 3 or 4 different talking heads for the architect or for the owner. So, for example, in last week's meeting that between my client and the contractor, the 2 principals that were at the meeting were the owner's reps identified in the contract. So they were able to speak on behalf of the owner and actually bind them to their statements. But if somebody was out in the field, and so we have our project manager, and he's the day-to-day person, but he doesn't have the authority to sign a change order or otherwise. He has certain other authorities. And so he's not necessarily identified in the contract as the contractual authorized representative. So this is something that 5.3 requires. There was in 4. I think it's 4.3, but I'm not sure, or 3.3, but 3.2 maybe, the architect had to provide an authorized representative. So it's the same on either side. 5.4, the owner shall furnish surveys to describe the physical characteristics, legal limitations, etc. So what this is here is, so when the architect comes in, the architect, they may visit the project sites and everything else, but they want to make sure that they're designing legally. So if there's a survey, they want to make sure they're not designing over a lot line, or that they're designing too close to a lot line. And in fact, some of the obligations that the architect has to do is they have to go in and they have to make sure that they have that they're following codes and regulations and laws. And in order for them to do that properly, they have to have the survey information, and since they can't get it, it's the only party that can get it is the owner, so it's the responsibility of the owner to go out and get the surveys. Sometimes the owners may hire a third party to get that information for them, but the owner needs to make sure that they provide that to the architect to have this legal description of the site. The last thing you want to have is an architect design a building, contractor build it, and then the next door neighbor come over and say, "You've built on my property." That's something. And if it happens, and the owner has not provided this information, neither the architect nor the contractor are at fault. Okay. 5.5. The owner shall furnish services of geotech engineers. So if you remember back in our basic services for the architect, the architectural services include mechanical engineering, electrical engineering, and structural engineering. It doesn't include civil, and it doesn't include geotech. So geotech, again, if you want to, the way to kind of think about it, if you can think about it in kind of in conjunction. 5.4 and 5.5, geotech is checking what the soil conditions are. Think about those two kind of subsets as together. And they deal with the land, the actual physical property. And so the owner is responsible for getting information about the physical property to the architect. So the architect, when it does its designs, is knowing the four corners of the property, where the building needs to sit, and the structural loads, that's your geotech and soil bearings and those types of things, as to what type of building and how the foundations are supposed to be. So architect provides this certain type of engineering that relates to the building itself. Owner provides information relating to the property. What's not listed here, but it's in this section 4.11, that's that chart I was telling you guys about, is another one is civil engineering. Civil engineering is grades and drainage and those types of things. Again, if you want to think about this in a group, the owner is the one that typically provides the civil engineer, and again, civil engineering relates to the property. So when you divide out services related to the design or the description, the building, the actual structure, electrical, mechanical, structural, that's the architect's side, and the land is the owner's side. 5.6, the owner shall provide supplemental services designated as the owner's responsibility in section 411. So this chart that I talked about, when you guys take a look at the actual B101 document, it's got a long list on the left-hand side of all of the types of services, and then it's got two columns, and one column says architect and one column says owner. And when the parties start talking about what supplemental services will be necessary for the project, you put a check mark or an X in one of those two columns. And so this says if there is a X in one of the columns, for one of the rows, in 411 that's checked off as owner, this is an obligation shall provide whatever those supplemental services. So one of them might be structural, might be civil engineering. You got to provide a civil engineer. Okay. Next, Article 5 or Section 5.7. If the owner identified a sustainable objective, the owner needs to fulfill its responsibilities in E204. So if you remember, last week we talked about Article 1.16. And that was this sustainable objective. Does the owner want the building to be green? And do they want that green building to be LEED certified or Green Globes or City of Chicago certified? Whatever that sustainable objective is. Maybe they don't need it to be LEED certified, but LEED-like. So at my last firm, we did a fairly significant expansion to our conference center. And in the process of doing the design work, the firm wanted it to be a green design, but they didn't want to spend the money for all the paperwork and the filing to get LEED certification for simply a conference center. So we had we had language as to our sustainable objective, but it wasn't necessarily a LEED objective. So whatever those are, you put this in this separate document, the E204. It's an entirely separate document. You put those as sustainable objectives, and whatever obligations that are identified in there for the owner, they must fulfill those. Just like the architect in Article 3, there was information that said that they need to follow or fulfill their obligations under the sustainable objective. The owner shall coordinate the services of its own consultants with those services provided by the architect. And then they need to provide copies of the scope of services of the contracts and requires consultants to maintain insurance, blah, blah, blah. So what we have here is, the example I've kind of thrown out a few times during our discussions is, let's say you're building a hotel, and the hotel has a restaurant where you've been able to secure the services of a named chef, somebody that won Top Chef or something to that effect. And so you want to highlight your restaurant. So you're going to have your regular architect do the hotel, you bring in a really good architect for that, but for this kitchen, you hire your own separate architect. So you have a contract for the hotel with your architect, and you have a separate contract with your kitchen designer. And so that would be their own consultants. And so what this provision says is, it's the owner's obligation to make sure that the kitchen designer's work is coordinated and consulted with the architect. So how does that work? What does that mean? Well, the architect is going to design, for this example, the space where the kitchen's going to be. And it's going to be a big box. That's all it is on the drawings, because they're not going to be designing the layout or anything. The kitchen designer is going to have its program or requirements of how much space it needs to be, and so that's the very first thing, is they're going to say, I need X amount of square feet, and I need this much ventilation, and I need this much electrical, and I need this much plumbing, and all the stuff that the kitchen designer is going to require in order to make sure that the project, that they can put their design in. And so the two have to coordinate. They have to coordinate. So when the architect is drawing the electrical power systems for the building, they have to have the information from the kitchen designer to put those into the drawings. And so how does that dialogue happen? Because there's no contract between the architect and the kitchen designer. The architect may have some of its own specialty, like a high voltage lighting design or whatever. And they're under their own contract, so they have their own methodology. But in this instance, you got to have a communication or a connection. And what it says here is that the owner needs to coordinate the services with its own consultant. So the owner comes to its kitchen designer and says, all right, I need you to have these meetings, and I need this and this and this. But if something goes wrong, if the information is not properly provided by the kitchen designer to the lead architect, that's the owner's problem, not the architect's problem, because they didn't properly coordinate. And sometimes what you need to do is, when you enter into the contract with your kitchen designer, because of this provision, you say, kitchen designer, you need to make sure that you're fully coordinated with the architect, and if you can't or don't do that, you have to give notice to the architect and me, and if you fail to properly coordinate, it's your cost and responsibility. The reason why is so, let's say we're finally building this, and you only have one contractor building it, and they're building it out, and things don't work. Well, you're going to first look to your main architect and say, did you do it right? And they're going to say, look, it's not my problem, see this provision. And then you're going to need to go back to your kitchen designer and say, did you do it right? Because whatever costs that the contractor is going to charge to fix it, to get it to work right, it's coming out of the owner's pocket. And the owner wants to have a place to get reimbursed for those costs. So the obligation in this contract is, it's the owner's fault. So when you're contracting with your kitchen designer, you want to make sure you can pass that responsibility down to them. The last part of this paragraph talks about insurance and otherwise, and that's, you always want to have insurance for the regular architect. If you remember in Article 2, and we briefly went over it because we had already had a whole lecture earlier in the semester on insurance. But since you're requiring your architect to carry insurance, it's only fair that you require your consultant to carry insurance. And the architect wants that as well, because that way, if there's something that goes wrong, and maybe it's even where there's two people that both parties have some fault or some liability. In those instances, it's better if the architect and the consultant have insurance, so there's two deep pockets, the carriers, from which you can get compensation to pay back. Okay, just checking the chat. All right, so any questions on this coordination and how the owner is responsible for coordination? You guys, that all make sense? Okay, good. This is something, and coordination, it's often kind of glanced over in construction contracts, and you'll see language, we'll talk about coordination, and the same thing in the owner-contractor agreement, but it is very important. Now, what I will say, I don't necessarily modify this often in the owner-architect agreement, but there's very similar language in the owner-contractor agreement. So let's say, for the owner-contractor agreement, in addition to bringing in a kitchen designer, you bring in a specialty kitchen contractor. So somebody that specifically builds out these high-end, high-tech kitchens, which is not unusual as well. So in that instance, it says, owner shall be responsible for coordinating the services of its subcontractor with the general contractor. For that, just as my own sense, I often change the contract to put the responsibility on the general contractor. And when we get to the 201, I'll talk about that more in detail. So sometimes I'll modify some of these provisions to place the responsibility back on the prime. Here, most of the time I don't put it on the architect, but I will do it on the contractor. Okay, next. 5.9. Owner shall furnish test inspections and reports required by law. So it talks about mechanical, chemical tests, and so forth. So if there's going to be certain types of materials being put in, or if the soils have let's say there's hazardous materials that are found in the soil after you do your soil borings and it turns out there's arsenic in it, or some other type of chemical, the owner needs to provide that information on the inspections and reports. And if any testing needs to be done, the architect may point out, hey, we got to run a test here, but it's the obligation of the owner to organize that, to pay for it, and to make sure all that information by law comes in. So, and again, you want to think about that. Sometimes there's tests being run on the actual construction of the property, of the project, but most of the time it's going to be done on the land. But, for example, I do a lot of work for power companies. And when you're making, when you make electricity, if you're dealing with some of the fossil fuels, if you're burning coal or you're burning gas, you're going to have emissions. And so one of the things that we do, what we build, what are called the back ends, so they're called AQCS or SCRs. They're basically huge construction projects that the end result uses either a mechanical, like either filters or otherwise, or they use a chemical process to remove the particles and particulates in the hazardous materials, the mercury and SO2 and other things that are in the exhaust from burning coal. So you don't, the old smokestacks used to have black smoke coming out. Now when you go by a coal-fired plant, you're going to see this white poofy, and that's mostly just steam because that smoke has been cleaned or scrubbed. So the construction project is to build the scrubber, the equipment that the smoke goes through to ultimately go from black to white fluffy. So in those projects, because it usually uses like a mechanical, a chemical process, or a combination of both, the contractor is obligated, when it's finished building this scrubber, that the emissions from the smokestacks has to meet certain EPA standards. And you test those at the end of the project. And if they're not meeting the standards, then the contractor's not finished and they have to do whatever tweaking to get the system to run properly. The test for those, to make sure that the contractor's completed, falls under this, 5.9. So even though that's one spot where you're testing the functionality of the building, but it's still up to the owner to perform those tests and to make sure that they're in compliance with the laws. So, 5.10, you got to provide legal and accounting services, no big deal there. 5.11, the owner shall provide prompt written notice to the architect if the owner becomes aware of any fault or defect in the project, including errors, omissions, and inconsistencies in the architect's instruments of service. So this is an important provision. Think about this as you can't put your head in the sand. This is kind of the no ostrich, no turtle provision here. So the contract's pretty clear. The party that's responsible for designing this project, that has to make sure that it complies with law, that it has to stand up, all the other things that it has to do, the standard of care, all of that is the architects. And the architects can't get out of that. That's their professional obligation. But what happens if the owner, by way of maybe having conversations with the contractor, maybe with its kitchen designer or some other separate consultant, or maybe the owner has their own people that are sophisticated with knowledge. What happens if they see something wrong in either the design or how the architect's performing its services? Well, this provision basically says, if you see something, owner, you need to raise it. You need to provide proper notice if the owner becomes aware of any fault or defect. Now, the becomes aware is important because it's not obligating the owner to seek out fault or defect in the project or the errors in the drawings. It's if they become aware. So the owner does not need to take on the obligations of the architect, does not need to have the professional standard of care. It doesn't need to act like that. That's not a contractual obligation of this provision. But if it becomes aware somehow, by their own knowledge or other people informing them, that's when the owner has to speak up. So this is important on that sense. Now, the interesting thing about that is, if the owner doesn't speak up, if the owner becomes aware of a fault or defect and doesn't say anything, does that mean the architect is off the hook? Hey, you didn't tell me it was wrong? Well, that doesn't mean the architect is off the hook. The architect always is responsible for designing in accordance with the standard of care, which means following all laws and codes and otherwise. So, if the owner doesn't know and doesn't say anything, it's all the architect's fault. If the owner does say something, well, it's still the architect's fault, but the architect could say, you failed, once you became aware of that, you failed to mitigate your own damages. And as a result, while you're suing me for $1 million, had you told me when you became aware, the fix would have been $200,000. So while I'm responsible for potentially $200,000 in loss, I'm not responsible for $1 million. So the architect never gets off if the owner's silent. But the architect can use this to reduce the amount of exposure that the architect has. Does that make sense? Okay. All right, 5.12. The owner shall include in the architect's communications with the contractor that relate to or affect the architect's services or professional responsibility. The owner shall promptly notify the architect of any substantive, any direct communications between the owner and the contractor otherwise relating to the project. And then communications with the architect's consultant shall be through the architect. So there's three things in here that are kind of important to think about on how the project goes. So as I told you, every 10 years they update the AIA contracts. So this is the 2017s. In the 2007s and before, both the owner-architect agreement and the owner-contractor agreement were written such that the contractor, if it wanted to communicate with the owner about design stuff, needed to talk to the architect. And the owner had it that way because the owner's like, well, oh, the contractor told me something about it, but I'm not a designer, so I don't know, so it's not my problem, not my fault. And the owner would be like, but you never told me, or the architect would be like, you never told me, I never was part of this, so why is it my fault? But contractually, it was. So in the redrafting in the 2017s, they recognized, hey, owners really like to get more involved in their projects. As the years go by, the owners are more and more involved. The projects are more high dollars, they're more sophisticated, the owners have a bigger stake in it. And so what was happening is they were recognizing that contractor-owner were talking a lot of times without the architect at the table. And so the first two sentences, the first one says, the owner shall include the architect in all communications, meaning you, owner, must make sure that the architect is aware when you're talking with the contractor. And then the second part says you have to notify of the substances of any direct communications. So everybody in the first paragraph, everybody's all in the know. And the second is, if you have that conversation with the contractor, you must make sure that the architect knows exactly what the substance of that communication was. And that then keeps the architect in the loop. So this is good for both the architect and the owner. In one sense, it protects the architect because now the architect, if it's left out, isn't still responsible, because in 2007s, if you were left out but something was important, the architect could still be held. This one takes care of that. It also recognizes that the owner, this is why it's good for the owner, is the owner can now communicate directly with the contractor about some design stuff. As long as the owner loops the architect back in, the project can keep moving forward. The same project that I had this meeting with yesterday, where they had the directors meeting last week about this incentive bonus, the architect had been left out of the loop in some of the communications because the contractor and the owner wanted to move faster. And it was important to bring the architect in, but the owner wanted to still keep moving because the architect itself was moving slowly. So this provision allowed the process to keep moving, the project to continue to stay on schedule, and it was not based on staffing or otherwise. As long as everybody got the communications, it went further. It went fine. The last part of this provision, it talks about communication, and this is kind of more the traditional. Communications with the architect's consultants shall be through the architect, meaning, well, the owner needs to, if you and the contractor are talking about the electrical lighting system, and the owner and the contractor have that without the architect, the owner has the obligation to tell the architect about that. But the owner cannot talk to the electrical engineer. That is one of the architect's consultants. So to get the information to the electrical engineer, the owner needs to only communicate it to the architect. And that's better. Single point responsibility, less chance of who said, he should, she should, and so you don't want to have that third party with whom nobody has a contract, or at least the owner doesn't have a contract, nor the contractor, having those direct communications. Any questions there? Okay. 513. Before executing your contract for construction, that's the A201 and whatever the A100 series is, the owner shall coordinate the architect's duties and responsibilities, etc. So what this says, and then provide the architect with a copy of the executed agreement. So what this says is, as I told you, kind of the AIA documents work as a collective suite. And so you may have, what we're going through today and last week is the standard, unedited, basic AIA form for the owner-architect agreement. And when we go through the A201, it'll be the standard basic. So the provisions where they overlap or talk about, when we talk about a contractor in here, it's going to be the exact same way in the other document. Or when we talk about the architect in the other document, the language is going to be the exact same here. However, if you look at one of my AIA contracts, it will be edited and redlined. There are various provisions that I like to add and subtract depending on who I'm representing. And so when you change the upfront owner-architect agreement, it may impact a similar provision in the owner-contractor agreement. So what 513 says is, okay, I now negotiate this owner-architect agreement. And the architect starts designing, and I put that on my shelf in my office, and it sits there. And then 6, 8, 10 months later, after the drawings are done, we bring in the contractor and we negotiate that construction contract. What this says is, before we finalize this construction contract, I have to pull that architect agreement off the shelf. And I have to look at all the provisions that changed from the standard boilerplate language. And if they affect how this contractor thinks the architect is going to work, I have to update it there. So let's go back to my kitchen designer example. If there are edits in the B101, the owner-architect agreement, that recognizes the duties and responsibilities of the kitchen designer different from the way this contract is written, I need to make sure the contractor knows that there's a separate kitchen designer, and that's what she's going to be doing on the project. So that's this coordination, this coordinate the two contracts together. And then the second part of this is, and then when you sign this construction contract, you give it to the architect, because the architect later on, if you remember from last week, in Article 3, it talked about the various phases, and the last phase that the architect has is the construction administration phase, and that's when the architect walks around the project site and makes sure that the project is being built in accordance with the drawings and specifications. And in doing so, the architect wants the rules to monopoly between the owner and the contractor. And the only way the architect can get that is to get a copy of that finalized signed agreement between owner and contractor. Again, all this is intuitively very simple, but you want to put it into the provision to the agreement so everybody knows, yes, you're supposed to do this, the owner's supposed to do this part, or the architect's supposed to do that part. Okay? Last one in here that I have highlighted is 5.15. Within 15 days after receipt of a written request from the architect, the owner shall furnish requested information necessary and relevant for the architect to evaluate and give notice or enforce lien rights. Very simplest to understand what this is saying here in this agreement. A mechanic's lien is a right that is created under the law to allow, in construction and property projects only, to allow a third party to assert what's called a lien, place of encumbrance on the title, in order to get paid for its work. Think about it this way. I hire an architect to design my house. The architect hires an electrical engineer. The electrical engineer provides $10,000 worth of services and doesn't get paid. But the services for the electrical engineering in the house is part of the drawings. And so when the house is built, the owner is getting the benefit of those $10,000 worth of services. Well, the electrical engineer can always sue the architect because presumably they have a contract together. But the architect may not want to pay, or maybe says you did it wrong, or what have you. And in the meantime, the owner is enjoying the benefits of that electrical engineering services because the house is finished, or it's being built, and there's going to have this really nice electrical system. And so the lien allows the electrical engineer to place a lien on the property and to sue the owner for its $10,000 worth of services. Same thing happens in the construction side. A subcontractor can sue. Because since there's no contract between the electrical engineer and the owner, they can never bring that lawsuit. It doesn't seem fair because the owner's enjoying the benefit. Same thing in the construction side. There's no contract between the plumber and the owner, so they can't bring a lawsuit because there's no contractual lawsuit, so they have this lien rights. So what 515 basically says is if the owner, and this back to the provision on the screen, if the architect says, I need to know what the information is about liens, whether it's the description of the property or whatever, the owner has to provide that information. And that's to make sure that the architect or its consultants can protect their rights for the services they've done. Okay? All right. Any questions on owner's responsibilities? Good. Cost of the work. So I talked about cost of work, and if you remember when we were going through Article 3, or maybe no, actually it was even Article 1, we were talking about the initial information, I pulled in a couple of provisions from Article 6, when we were talking about the difference between budget and cost of the work. So we'll go through this hopefully relatively quickly. So definition, cost of work, you've already seen this before, and that was highlighted in blue, is the total cost to the owner to construct all elements of the projects designed or otherwise specified by the architect and shall include the contractor's general conditions, costs, and overheads and profit. So it has nothing to do with paying the architect, it has nothing to do with buying the land, other stuff. It's what it costs to actually build the project. Effectively what you're paying the contractor is the cost of the work. Now, the one thing that's a little different in sometimes how the definition looks, because it says, and shall include the contractor's general conditions, cost, overhead, and profit. The way cost of the work is defined in very detail in the owner-contractor agreement will not include overhead and profit, because that's normally a markup, a percentage that they add on top of things. So if it just said cost of the work is elements designed to build the project, that wouldn't be necessarily everything. That's why they say including the general conditions, overhead, and profit. But just think about it as, for purposes of this contract, what it costs to build the project. 6.2. The owner's budget, so that's different, for the cost of work is provided in the additional information we know, and is adjusted throughout the project as required under 5.2, 6.4, and 6.5. So you have to keep up, and this is kind of repetitive of what's elsewhere, but when we're in this cost of work section, we want to define it. So there's a preliminary estimate of the cost of the work that's provided by the architect, and if that gets increased, then the cost of work, or your budget has to be increased. So you have to have this give and take back and forth to make sure that the budget and the cost of the work match or stay within the same parameters. The final kind of highlighted portion of this provision says, the architect cannot and does not warrant or represent that bids negotiated will not vary from the budget of the cost of work or any estimate of the cost of work prepared or applied the architect. So what this says, this provision, the last part of this provision, is that I know I'm the architect and under Article 3 at the end of schematic design, design development, construction document phase. At the end of each of those three phases, I need to update my estimate for the cost of work. And I need to make sure, as if I'm communicating with the owner, that my estimate stays within the owner's budget. And if it goes out of the budget, we have to have a conversation. So that's all in Article 3, and we talked about that last week. What happens, though, is sometimes you blow the estimate. And if that happens, then the owner's like, well, you promised that we'd be able to do this house for $1 million, and the bids are coming back at 1.3. That doesn't mean that the architect has to pay for the additional $300,000 over what was in the preliminary estimate. And the reason why is because this provision here says the architect cannot and does not warrant or represent that the bids will not vary from the budget. So the architect is doing its best job possible to design in accordance with the budget and provide estimates for the cost of the work. But until it goes out for bid, you just won't know. So let me go back to the project I keep raising today. That they had the meeting with the owners, the principals last week. So we went out to bid for that project in March and April of 2020, and the architect had made a number of cost estimates. It's a fairly expensive building, just about $200 million, and that was the owner had a very strict budget of where they needed to be. And went out to bid, and the bids came back the cheapest bid came back at about 18% over the architect's estimate. As you might imagine, the owner and the management of the owner were a little bit hot, because they're like, we've engaged you for 2 years, we have gone through this over and over, how did you blow it? Well, one of the things that happened is COVID hit. The costs were different. Was that the reason why it was 18% over? Who knows? That was one reason, I think. I think there was other reasons involved. I think the architect maybe was a little bit trying to make sure that they kept the owner happy. Who knows what it is. But with this language here, the architect was able to say, I didn't guarantee you. And that's what's important. Because I'm not going to be the one that has to pay for this 18% overrun. Now, how do we fix it? That's coming up in Articles 6.4 and 6.5. But this is I won't say it's a complete get-out-of-jail-free card, but it is to say, I, as the architect, am not going to give you any guarantee of the pricing. That's not what I do. I design it, I do everything I can, I do the best I can. As long as it's within the standard of care, then we're okay. So when we get to 6.4 and 6.5, I'll explain how we resolved it. So 6.3 kind of talks about what the architect needs to do in preparing that estimate. They have to have contingencies for the design, price escalation. Maybe there's things that the scope is going to change. And so what this is talking about here in 6.3 is when they're preparing the estimate of the cost of the work, the architect should build in some leeway, some fudge factor to make sure that we're going to not blow the budget. So that's your responsibility. And it's kind of interesting in the sense that you think about that a contractual obligation for you as the architect is to make sure there may be some fluff in the budget when you're doing this estimate. But it's for everybody's benefit. You don't want to over-design and be in the situation we were last spring where the project was 18% over budget. It does include also, if the owner wants detailed cost estimating, they can provide that as an additional service, so they get paid more. So sometimes architects will actually have a cost estimator on staff, but they're not designers. Their job is specifically to figure out what the costs are. I have a project right now, a very small project. Well, small is depending on who's paying the bill. But we have a fix of a problem for about $1 million, and the owner and the engineer think that the contractor's pricing is too high. So we're going to bring in a specialized cost estimator to see if we can figure out, is the contractor's pricing at $1 million too high, or is there a better way to get the numbers down? So this provision says if the owner wants to have detailed cost estimating, the architect shall provide such services. They get paid for it, but they have to provide it. Okay, 6.4 and 6.5. And 6.6 is also in how we fixed it. So, in 6.4 it says, the bidding negotiation is not commenced within 90 days after the construction documents are submitted. So we go through, we do the design, schematic design, design development, construction documents, and we give them to the owner, and we say, okay, go out to bid. Well, if the owner doesn't go out to bid within 90 days, the architect can come back and adjust the cost of the work budget. And they're going to say, look, my budget was based on when I gave you the drawings. And if you waited 90 days, there's a lot of stuff that could happen that could change and affect the pricing. That was part of the COVID thing that happened with this big project of ours. The architect had been working on this thing for many years, or for a couple years, and we were supposed to go out to bid right after the first of the year. But there were some changes by the owner, and so we wanted to get all the drawings right, and we wanted everything just right. And it turned out that the drawings didn't go out for bid until April 1st. Well, that was right after COVID. And so the architect, when we talked about how the fix was, they're like, well, we gave you the stuff in January. We went out in April, and COVID hit, which that's things that affected the construction market. So we can't be held to that budget that we gave you because life has changed. So that was a real-world application of 6.4 of what happens when things that can impact in the market what the pricing are. So, 6.5. If at any time the estimate of the cost of work exceeds the budget, the architect shall make appropriate recommendations to adjust the project size, quality, or budget for the cost of the work, and the owner shall cooperate. So this says, I got my $1 million housing budget. I told you that. You come back to me, and I told you everything I wanted in the house. You come back to me and you say, okay, I'm estimating, this is before we even go out to bid, my estimate is it's going to be $1.2 million. So You can either increase your budget or we can change your design. And then the owner shall cooperate with the architect. Either the owner has to do one of the two. If it won't change its design, it's got to change its budget. If it doesn't want to change its budget, it has to change the design. So these are shall obligations for both the architect shall and the owner shall obligations under 6.5. And that's one of the things that we did when we got this budget, this $200 million facility. It was 18% over budget. There was a big discussion about what needed to happen. So, if the owner's budget under 6.6, if the owner's budget for the cost of the work at the conclusion of the construction document phase is exceeded by the lowest bona fide bid or negotiation proposal, so that's what happened. The lowest bid that we got on this project was 18% over budget. What happens? The owner shall give written approval of an increase in budget. That wasn't going to happen on our end. They would authorize rebidding or renegotiation of the project. Well, we were at an RFP, so we actually had 3 or 4 bids that came in. All of them were over, and so we weren't at the point of rebidding yet, and that was a discussion that had to do. Terminate in accordance with Section 9.5. Well, we didn't want to terminate the architect. We liked the architect. We've been with him for 2 years. And then the last one was, is to revise the project program, scope, or quality. And that's what we ended up doing. We went back and we said, we can't afford this price for this project. What can we do? And there was multiple structures in the project. So we had to take one structure that was a 4-story structure and we had to reduce it to 2. There were other elements about the design that were, we had to take some of the more aesthetic, artistic elements of it because it was a production facility and eliminate those. So we had to change the program in order to make sure that we remained within the budget. So that was based on this, because it says the owner shall. We had one of these 5, the others implement mutually accepted alternatives. We had one of these 5 obligations or alternatives to choose, and we chose sub 4. Revise the program, scope, or quality as required to reduce the cost of the work. So that's what we did on the owner's side. Now, as you remember, we had this provision where the architect says, I can't guarantee the pricing. And now we got the owner that says, okay, we got to change the design. But boy, it seems kind of unfair that if the architect just blew the bid, yeah, there was COVID and everything else, but 18%, no, that was pretty hard. But the architect kind of really blew it. So why should the architect get off? Because if we're going to be revising the program, they're going to have to issue new drawings. So yes, we opted to do section sub 4, 6.6.4, to revise the program. But the only party that could revise the program is the architect. So how do we make sure that it's fair? Well, that's what 6.7 says. If the owner chooses to proceed under 6.6.4, which is what we did here, revise the program, scope, or quality, without additional compensation, the architect without additional compensation shall modify the construction documents as necessary to comply with the owner's budget. So what this says is, we have $200 million budget. You knew it. You always told us we were under budget. In fact, they said we were actually about 10% under budget, which was kind of ironic that we came in and we were 18% over. And so we opted to revise our scope. And as a result, the architect here had to redo the designs for free. So all the hours that they went ahead and spent on fixing the scope to match the budget, because the bids were too high, the architect did not get paid for them. And that's based on 6.7. That's important. I think it's fair. If you think about it, if the owner has said all along, here's my budget, and the architect has all along said you're within budget, and then it comes in that you've blown the budget, and the owner has to then revise what the project is going to be like. It's only fair that under 6.7 the architect does it for free. Now, as a tip for you guys, often the architect will put in a percentage here. They're not going to say if it's $1 over the budget. They're going to say if it's within 10%. And that's what we actually had. We had a number of 10% on this. We negotiated that if the bids came in within 10% of the budget, the architect and the owner needed to redesign, the architect would pay for it. If it was over 10%, the architect had to do it for free. Well, we were at 18%. There was never really a question, so we made them design for free. They pushed back. They tried to use the COVID argument. They tried to do some other stuff. But at the end of the day, they ended up doing the work because contractually they were obligated to do it. All right, that's it for cost of work. Any questions there? Okay. Article 7, this is about the instruments of service. So I've said this a few times in the semester. Obviously, the services you provide is how you make your money. You know, you're going to design services, you consult, all this other stuff. But you want to make sure that this is one of your most important rights that you have. Even though the owner's hiring you, even though it's the owner's idea, they want to have this type of, they want this toy factory or your $1 million house or whatever it is. It's still your intellectual property. It's your creative right, your creative license, your creativity that makes these drawings and specifications. And so, you have the copyright. Under the law, you have the copyright. You own that in the drawings. They call it the instruments of service. There's a definition coming up here because it's a defined term. The I and the S are capitalized. It includes this whole laundry list of stuff, so you don't have to repeat it everyone else. But what this is, so we're going to talk about the value of your rights and what's in them, and then how does the owner, if you have the copyright, how does the owner get the ability to use your drawings? Because technically, if you drew a building under the Architectural Works Copyright Act of 1990, and someone built that building from your drawings, that construction of that building technically is an infringement of the copyright. Because it's a copy. It's a copy of your drawing. Your drawing becomes a three-dimensional, it becomes that building, that's an infringement. Because somebody has made something and made money off of you from your drawings. So how does then construction happen if you own the copyright and every time somebody builds a building, they're infringing it? Well, it talks about here in 7.1. They're going to transmit, the transmitting party, the copyright owner, is the copyright owner of such information and or has permission from the copyright owner to transmit such information. So this right away says, we recognize that the instruments of service, your drawings and specifications, you, the architect, are the owner. And when the owner is giving that, they're transmitting that to the contractor. They have the permission from the architect to give those drawings for the contractor to use. So that's what 7.1 says. 7.2. The architect and the architect consultant shall be deemed authors and owners of their respective instruments of services. So the electrical engineer is the author and the owner of its electrical drawings. Even though it's rolled into the architectural whole set, there's going to be your architecturals, your mechanicals, your electricals, your structurals. All those drawings will be in the full set of drawings that are provided to the contractor to build it. But each consultant that prepared the electrical, the mechanical, and the structural, they own their respective instruments of service. They're the copyright owners. 7.3. Upon the execution of this agreement, so once you sign this agreement, which actually is before any drawings are created normally, the architect grants to the owner, I give to you, owner, a non-exclusive license. I'm giving you a license to use my instruments of service. But it's narrow, solely and exclusively for the purpose of constructing, using, maintaining, altering, and adding to the project. So you can use it to build the project, you can use it to do additions to the project, you can do maintenance, but that's it. You can't use these drawings to build that $1 million house twice. You can use it for this project and this project only. You can't have, sometimes you'll have a project where the developer's going to put up a series of high-rises, but they're all going to be the same. In fact, when I used to live in the city, there was a apartment high-rise right behind me, and it was a huge lot, and the initial plan was for the owner to develop 3 towers, and they developed the first one, and only the first one. Well, if he wanted to do the second tower, and it was supposed to be literally a mere cookie cutter of the first tower, if the developer wanted to do the second tower, they did not have a copyright license. They didn't have a license for that second tower. They would have gone back to the architect and say, I want to do the second tower. Will you grant me a license for that? And there would be negotiations and price and a whole bunch of other stuff. So that's what this first portion says. And then the second of it says, the license granted in this section permits the owner to authorize the contractor, subs, etc., as well as the owner's consultants, so that kitchen designer and separate contractors, to reproduce these instruments and services. You can make copies, guys. Even though it would be copyright infringement, I'm giving you the authorization of this license to make copies of extra sets of drawings and specifications solely and exclusively for the performance of services or construction of the project. Again, it has to be tied to the specific project. Last part of this provision that's important. The architect rightfully terminates this agreement for causes provided 9.4, and that's just basically I don't get paid or the owner's in breach. If I, the architect, terminate, I fire you, owner, this license goes away. And so that's one thing where I think I've told you guys the story of where I represented the lighting designer. They got fired. They weren't getting paid. The owner brought in a new lighting designer to build the to finish out the drawings, and the project was currently underway. They were owed about $450,000, and I went to federal court because copyright law is federal law, and I went under an injunction under Article 7.3, and I said, we haven't been paid, we terminated our agreement, the license has expired, they are infringing our copyright, and we were able to get the project, get my client paid relatively quickly because this is pretty cut and dry. So that's the use of this provision. It's a very powerful provision. It's very protective of you as the architect, and it should be because it's your work product and it's how you guys make. 7.4. In the event the owners will use the instruments and services without retaining the author of the instruments and services, so they build that second tower, and I don't hire the first architect, but I have the drawings. The owner releases the architect and the architect's consultants from all claims and causes of actions arising from such uses. Even if, and here's the interesting thing, let's say that a portion of the drawings were incorrect. They weren't a code. The first building gets built, and maybe the contractor catches it and fixes it. Whatever happens, it's not a problem. They build the second building, and the owner doesn't go to the first architect and builds the second tower. And this defect still exists in the drawings. And it's constructed, and the defect causes an injury, causes some error, where the wall falls down. Because the owner didn't hire the architect, the architect that drew them, for this phase 2, there's an argument that can be made that even though the architect did not comply with the standard of care, even though there's an error by the architect, because of this provision, because the first architect was not hired, the owner has released that architect from any claims. So the cost and the damages relating to the wall falling down, even though it's the architect's fault, the owner cannot sue the architect for it based on this provision because they didn't hire him. And the reason why is you're like, well, wait a minute, the architect still screwed up. I thought you said earlier, like, just because the owner doesn't say something, the architect's still liable because the architect ultimately screwed up. The architect's response to that is, under this one, is, okay, yeah, we built the first phase, the error is in that one, nobody caught it, maybe the contractor caught it, I don't know, but nothing has come from it, so you don't have a loss yet. But I may have discovered that in phase 2. I may have seen it. It may have come up if you had me on site. But you didn't. So you never gave me an opportunity to fix my mistake for phase 2. And since you didn't give me the opportunity, I can't be held liable for not performing in accordance with the standard of care for phase 2 because I was never involved. And our contract's for phase 1 only. You can't create some contract with me for phase 2 when we don't have anything. So you can't sue me for that. So that's what this is here. And in fact, it goes further, that's the second half of this provision, that the owner agrees to indemnify and hold harmless the architect and consultants relating to any of these claims that might come up. So what does that mean? Let's say the wall falls down in the building of phase 2, and it falls on the tenant that lives in that apartment. And the tenant is badly injured. The tenant sues the owner and finds out that the architect, well, they didn't work on phase 2, finds out who the architect is that designed it. Well, this provision says the owner releases from claims, but the tenant doesn't have a contract with anybody. So under tort law, as you remember, the tenant could sue the architect because the architect screwed up. Tenant's like, you designed it, you weren't performing to standard of care, I got injured because of your screw-up architect, I can sue you. And it's right, they can. But what this second half of this provision says is, what the owner needs to indemnify and hold harmless the architect, what that means is, the owner needs to step in, and if there's a claim against the architect, the owner has to pay for the architect's damages. So it goes to a jury, and the jury says, okay, it's $1 million loss, and they apportion the fault, and they say, $200,000 is the owner's fault, and $800,000 is the architect's fault because they designed it and the wall fell down on what they designed. Because of this provision of indemnifying and hold harmless, the owner has to pay the full $1 million. The architect doesn't have to pay anything because the owner didn't bring in the architect. And the owner couldn't let the architect protect itself against third parties, and so the owner has to indemnify the architect for these third-party claims. Except for the license granted under this Article 7, no other license shall be deemed granted or implied. So you can't have, if I design for you the building that's part of the project, I give you the license for that. If I'm doing something else for you, I don't give you a license for something else. Or I'm not giving you a license for phase 2. I'm not giving you a license to take some of my drawings and repeat it not on a phase 2 but elsewhere. It's narrow. It's specific for this project, what it says and what it's used for. I can't give these drawings to a friend of mine. I can't give these drawings to some other company. If I leave the company I'm with and go somewhere else, I can't give them to those. The project, I can only give them to the contractors and the subcontractors and my third party, my kitchen designer, and I only have a license for that. That's it. And if I do any of those, if I do go to phase 2, if I take the drawings for myself, if I give them to somebody besides the contractor and the subcontractors, this says here, any unauthorized use, so all those are unauthorized, shall be at my own risk. So this provisions, 7.3 and 7.4, are truly the get out of jail free cards for the architect. Hey, I'm going to design it for you. You got to pay me for it. But if you don't pay me, license terminates. Or, if you're using it for another project, I have no responsibility. You have to handle that yourself. So, very powerful provisions, Article 7. You own the copyright, you own the control, licenses are limited, and if the owner deviates from those, owner, buyer, beware. It's owner's risk, not the architect's. So this is one of the best provisions for you guys in this agreement with respect to when there's a deviation from the project and what's going on.
Let's fire back up again. Now we're going to talk about claims and disputes. So one of the things that obviously happens on every construction project is there's going to be claims that are made. I've never had a construction project where there wasn't claims. And claims don't necessarily mean a bad thing. It just means that the drawings weren't sufficient or there wasn't enough information. That doesn't mean that there was an error necessarily, but there's a claim by the contractor that says I should get paid more money. Or sometimes it's a claim by the owner that the contractor screwed up. Or it's a claim that there's an architect that they did something wrong. So in every contract, you want to make sure, whether it's owner-contractor or owner-architect, or even just in a general contract you have between the parties, you need to have some type of rules, the monopoly rules, to figure out what happens when there's a dispute. How do you solve those disputes with the claims and disputes? So that's what Article 8 talks about. 8.11. The owner and the architect shall commence all claims and causes of actions, whether in contract, tort, or otherwise, within the period specified in the applicable law, but in any case not more than 10 years after the date of substantial completion of the work. So this is a time frame in which you have to bring that. We talked about statute of limitations in our second or third lecture that said you have so many years in Illinois. It's if you knew or should have known within 4 years to bring a claim, and that's the period where it says the period specified by applicable law. But in any case, not more than 10 years after substantial completion. Now, if you remember in Illinois, it's that 4 years, but there's the 10-year discovery period, so that's called the statute of repose. So it could go up to 14 years. So this provision would limit it to 10. So if you're in Illinois, turn this off. If you're in Illinois, this would limit it to the 10 years, even though the statute says 14. So when I'm an owner, when I represent an owner, I strike this 10-year provision, and I just say within the period specified by applicable law, and I strike the 10-year provision after that. But generally, it's saying at the top of the longest you can wait is 10 years. So that's what that says. It creates a contractual statute of limitations. 812. To the extent that damages are covered by property insurance, owner and architect waive rights against each other and against contractors, etc., etc. So as long as, except for that they may have proceeds of the insurance. So what this says is, if there is property insurance and there's a property loss, and we can recover under that, then we're going to try to get the proceeds from that insurance that's set forth. And so that's just an insurance one. You don't have to worry about that for the exam, but there are provisions that talk about how insurance is going to be used on these projects. 813. This is something that's in almost every construction contract, whether it's design professional agreement or construction with the owner contractor. Architect and owner waive consequential damages for claims, disputes, or other matters in question arising out of or relating to this agreement. So consequential damage is something that is not directly related to the project. So I have this very instance in a construction claim right now. I have a client that opened a hotel. The hotel was up and running, and then there was some damage to a bar area. The pressurized system for the beer and the other alcohol, it exploded. And as a result, they had to shut down the bar, they had to rebuild part of the bar, they had to rebuild some of the floor, and they had to shut down a portion of the hotel restaurant that was making money for them. So the cost to fix the pressurized system, that's directly related to the work in the project. The cost of fixing the floor, the cost of fixing the damaged bar, those were all costs directly related to the project. Consequential damages as a result of that is the lost revenue for the business, so business interruption. And so the waiver here says is the owner can't sue if in this case it was against the contractor, but it's the same concept. If the reason why the pressurized system blew up was because of the design error, the owner could sue the architect for the cost to fix the physical stuff that was damaged, but could not sue the owner for the lost profits, the lost revenue that they made because they had to close the restaurant, because that's a consequential damage. The reason why you do this in construction projects is because there are so many potential areas of where there could be lost revenue or lost things that it could be it could just be massive. So it has become an industry practice that there should be a mutual waiver, mutual owner and architect both waive, consequential damages. The same thing could be as, so let's say the owner fails to pay the architect timely. So how does it work the other way? So the owner fails to pay the architect timely, so the architect slows down the process, and the project gets slowed down. And the architect thought that they were going to be done with the design process by December 31st, and they had a architect, one of the guys in the team, one of the architects, she was going to go and work on a new project. The owner slow drags it, and the project gets extended out because of the owner's fault into January and February.
Well, the architect can't take the lead architect off the project because she's part of the design team. And as a result, the architect loses a really nice commission that she was going to work on. This architect, she was going to work on this other project starting January 1st. And so as a result, the firm loses the commission. Well, clearly the owner breached the contract by slow paying, and clearly it's the owner's fault that the work went out into January and February for the first project. So the architect can all the costs that they incur to do additional work and everything else, the architect can sue the owner for those additional costs. But they can't sue for the consequences of losing the other project. Let's say that they lost, $1 million commission from the other project they weren't able to put the architect on, so she couldn't be there. This waiver of consequential damages says the architect can't sue the owner for those consequences. So, mutual is important, and waiver, and it's, again, you're going to see this in the owner-contractor agreement as well. That make sense? Okay. Mediation. So, I think we talked about this as far as different ways that you can have dispute resolution. And so what the AIA contract has done in the architectural world, or the construction world, the construction industry, is construction litigation, where you actually go to court, can be very complex, very expensive because there's so many drawings and so many documents. You got invoices, you got drawings, you got change orders, you got RFIs. The amount of paperwork in construction projects are massive. And so as a result, if you had to only litigate, if you could only go to court the way to solve disputes, it would just be way too cost prohibitive for everyone. So the first phase in virtually all construction contracts is mediation. And if you remember, mediation is a non-binding resolution between the two parties. So they have this neutral that sits between the two parties and helps them solve on a business level the dispute and the cost. And so what it requires here under the AIA contracts is the first step you must do is you must mediate. All claims related to this shall be part of the mediation. And so there's timing and deadlines that are applicable, and if there's liens or otherwise, but that's the first phase is mediation. And it says, they shall endeavor to resolve claims and disputes and other matters between mediation, and then if they can't do this, the mediation shall proceed in advance of binding dispute resolution, which could be either arbitration or litigation. So we have a step process. First step is mediation. Second step, if they can't solve it, this says the second step will be some binding resolution, and it could be litigation or arbitration. So how do you know? Which are we doing first? What are we doing after if the mediation doesn't work? Well, 8.2.4 says, if the parties do not resolve the dispute through mediation, then they shall go to binding dispute as one of the following. And you have to, when you fill out this contract, you have to check the box. It's either arbitration, litigation, or others. Sometimes they have things called MED-ARB or ARB-MED. There's these specialty type of special masters or otherwise. Traditionally, it's going to be arbitration or litigation. For my preference, when I represent, whether it's an owner or a contractor or an architect, my preference is to do mediation than litigation. And we'll talk a little bit about some of the, and I think I've mentioned it before, some of the problems with arbitration. I don't think it used to be, as it was a more cost-efficient method and kept you out of the courts and kept you out of the papers. I don't think it's the benefits are as great as they used to be. I think arbitration is as bogged down as litigation is. And you can't have, there's no right of appeal. So I almost always, when I fill out my contracts in construction, the mediation is mandatory, is I click on litigation. Now there may be times when you represent an owner where they don't want their information to be in a court of law. So private owners, they want to have arbitration, or they want arbitration instead of mediation. Or they may be an area in a jurisdiction where they think arbitration will be more beneficial to them. Maybe the public sentiment against them seeing their name in the paper in litigation is not to their favor. So there are some circumstances where I communicate with my client and talk about them that we will go arbitration, but most of the time I'm going to go mediation followed by litigation. So if you go to the arbitration, there's a process under 8.3. They go arbitration. It's going to be in accordance with the rules from the American Arbitration Association, and they have specific rules of how the arbitration proceeds. You can change this. There are other arbitration organizations out there, so you can modify the contract. But the American Arbitration Association is the most predominant, certainly in the construction industry. So everybody kind of knows what these rules are. So this is normally a really kind of a non-factor. Almost everybody, if they're going to go arbitration, will proceed with this as written. You have to file a demand. It talks about when that is. A demand is kind of like a complaint where you lay out what all the problems are in the project and who is responsible for what. And it can't be later than the statute of limitations. So even though arbitration is not in the courts, what this provision 8.3.1.1 says is we still have to follow the rules of the courts with respect to timing of the lawsuit, statute of limitations. 8.3.2, the agreement to arbitrate shall be specifically enforceable in any court of law. So what this says is you mediate, you can't solve it, you have $1 million dispute, and you go to arbitration. And arbitration is kind of like a trial, but it's not a judge and jury. It's a panel of 1 or 3 individuals that most likely will have a specialty knowledge in the industry. They'll either be a contractor or an architect or a construction lawyer or something like that. And you're going to put on your evidence, and at the end of the arbitration hearings, they're going to come up with a verdict. They're going to have a ruling. So they're going to say, okay, you were suing for $1 million. I found mostly your case I agreed with. I'm going to award you $800,000. Well, how do you collect on that? Well, the arbiters don't have the force of being able to send a sheriff or to garnish somebody's wages or whatever. So what 832 says is basically you can enforce the arbitration judgment, that $800,000 award, in court. So you get the award, you go to court. If you don't get paid right away, you get the award, then you go to court and you file a claim in court that says, I have an arbitration award for $800,000, and then the court simply enforces it. They don't hear any merits, they don't hear any testimony. They look at the arbitration award, it says party A is awarded $800,000, and they enter a judgment, and then that judgment can be given to the sheriff, and the sheriff can go out and do what they need to do if the other side isn't paying to get those funds for you. So, and then 833 says the arbitration shall be final. Any questions so far on mediation arbitration? 834 talks about consolidation and joinder. So what this basically means is you can consolidate arbitrations together. So I have this project where the wall falls down and someone's injured, and I myself am injured for the cost to fix the wall and potentially having to pay the injured party. I bring an arbitration demand against the architect because I have it in my B101 contract. But the contractor may have screwed up too. So I bring an arbitration demand against the contractor. Well, that's a separate proceeding because it's a separate contract. That's not the same one as this one. So what this provision says, 8.3.4.1, means that either party here, the architect or the owner, can consolidate and bring everybody together as long as they have common facts and questions and similar procedures and rules. So if I'm using AIA contracts, everybody's going to be under the American Arbitration Association rules. It's going to be the same project, so the same set of facts. And so it would make sense that to bring everybody to the same party. So it's going to be owner, architect, and contractor all in one arbitration as opposed to being separate. I have a case right now. It's about a $7 million claim. And there was no consolidation provision in the agreement. It's an old AIA agreement. And this provision does not exist. And so I had to bring 2 different arbitration demands, and I have requested from the contractor and the architect, would they agree to consolidate Now, we are still in the mediation process, so we have not gotten to the arbitration process, but we'll eventually probably get there. The contractor has agreed to consolidate. The architect has not. I didn't negotiate the agreement, so this provision that should be there is gone. Whoever struck it shouldn't have it stricken. So now I'm potentially faced with a fact where my client may have to arbitrate the same case twice and potentially have different outcomes. In one case, the arbiters for the architect may say, maybe the architect screwed up, but they were only worth 20% of the screw up, the other 80 is the contractor. And in the construction arbitration, those panel members, because it's separate, may say, well, the contractor was only responsible for 40% and 60% the architect. Now I have two inconsistent decisions because I don't have a joinder clause. So it's important, especially in construction, to keep everybody together. So this is important just procedurally, so everybody's at the dance at the same time. 8.3.4.2, either party's sole discretion may include joinder persons or equities substantially involved in common question of law or fact. So it doesn't necessarily, so if you look at 8.3.4.1, these are if the arbitration permits, and there's substantially questions and similar procedural rules. This one's a little bit that they can bring somebody in on the common questions of law of facts, but not all of those, provided that the parties sought to be joint consents in writing. So this is the provision. I don't have the automatic consolidation. I have this provision. And so what I'm saying to the architect now, who's kind of being a holdout, is I'm saying, guys, they have similar common questions of law and fact. I'm asking to join the parties. Will you consent in writing? Contractor has consented in writing. The architect hasn't. I think ultimately the architect will, but at the same time, I have to get it through this provision. So, just as a procedural matter, this is important. Any questions on arbitration and mediation? Okay. Article 9, termination or suspension. So, if something goes wrong in a contract, you may end up terminating. Now, termination, I will say this to you guys, as I say to every single client I've ever had, termination is the nuclear option. Because termination, in any contract you have, it could be very expensive, but in construction, it is always prohibitively more expensive. If you have to terminate your architect before the project's over, you may or may not get the license to use those drawings. And we'll talk about how these provisions allow for that depending on the circumstances. If you can't use those drawings, you have to pay the architect to start over, the new architect. And that's going to be expensive. And especially if you're under construction, well then you don't even have the license to use those drawings to complete the construction. You have to use new drawings. So you're going to have new costs there. And if you terminate a contractor, well, they have this host of knowledge. You have to go out and get a new contractor. You have to get new subcontractors, all those other things. So you really never want to be in a situation for termination. You want to do everything under construction and all possible options to avoid termination. But it happens. Because it happens, you have to have language in the provision. So, 891. How can the architect terminate? Well, the first one's pretty simple. If the owner fails to make payments to the architect in accordance with its agreement, it's substantial non-performance and the architect can terminate. That's easy. 10 days, or you give 7 days written notice, you can either suspend, and then you give 7 days written notice, and you can terminate. You don't pay me, I'm not going to work for you, I'm terminating the contract. Now, with suspension, you can resume the services. Let's say it's just suspension, and the architect decides to come back. This last part of this provision is important. It says, before resuming services, the architect shall be paid all sums due. So if the owner hasn't paid, it's not just, oh, I promise I'll pay you, and then the architect starts working. One, you have to be caught up to date. And then any expenses incurred in the interruption and resumption of the services. So if you're off for like a month, and you had to adjust your architects working on the project, and then they had to get back up to speed, and there's costs for that weren't in the original contract. If the owner has failed to pay, and it's the owner's fault, the owner has to pay both the catch-up money and additional costs for the architect to get up to speed. Also, the schedule, the architect and when it has to deliver things have to be adjusted. So if we're down for a month, everything gets pushed out a month. So, while, again, intuitive and makes sense, you want to put it in writing to make sure in the contract that that's the process when you bring everybody back up to speed. 9.2. If the owner suspends the project, so this is a situation where the owner says, okay, let's just halt for a while, I need to make sure that my funds are in the right place, or whatever the reason is for suspension. Maybe there's a problem with the city and I'm not getting the proper zoning permits. Maybe I want to have an extended bid period, so we're going to not go out to bid right now. Whatever it is, the architect needs to be compensated before it's suspended. So the architect's still designing, and they stop at August 1st, and they don't resume back till October 1st. Everything the architect did through August 1st, they have to be paid for it. So because of the owner suspension. And then when they start back up in October, if there was any cost the architect incurred in the shutdown, the interim, the owner has to pay those fees, and again, the schedule needs to be adjusted. If the owner suspends the project for more than 90 days, under 9.3, the architect can terminate the agreement in 7 days written notice. So 9.1, if you recall from on screen, fails to make payment, you can terminate. So 9.1 is a payment one. 9.2 and 9.3 are suspension. So we're just stopping the project for a little while. And 9.3 goes so far as this: if the project is suspended for 90 days, the architects can terminate. They can say, I'm done. Now, as a matter of course, when I represent an owner, I strike 9.3. What I say to the architect is, if I'm shut down for 90 days because I can't get financing or this and that, I understand you should get paid for your downtime, but the cost to me if you terminate, let's say we're 6 months into an 8-month design process, and then I have to shut down for 90 days, and you terminate, well, the license goes away, I have to start from scratch. That's just so prohibitive against me. I can't let you terminate just because I had to suspend because I had to go get financing. What I will let you do is suspend yourself, and then when you start back up, I'll pay you for your additional costs. So that's what I do as an owner, but 9.3 doesn't have that. 9.3 says 90 days, the architect can walk away and get paid for everything they've done to date. Now, why would the architect do that? Well, because they have a project, they have a commission, and if the guys are going to come back, well, maybe they see 90 days is going to turn into 180 days, and they don't want to be stuck with it. Or maybe they have that new great project coming down the line, and they need to put their senior architect, she needs to work on the next project. So sometimes they may want to terminate because financially it's a better business for the architect. But most of the time, the parties are going to sit down and talk and try to work it out, not terminate, because as I said at the beginning, terminate's the worst thing for either party. Now, either party here can terminate the agreement upon not less than 7 days written notice should the other party fail to substantially perform in accordance with the terms of this agreement through no fault of the party initiating termination. That's basically saying if one party has a major breach of the agreement, and it could be payment, but we already know payments 1 and 9.1, either party can terminate. Well, how do you determine if there's a major breach? Well, if you remember, Article 3 details all the obligations that the architect's supposed to perform under the agreement, and Article 5 details all the obligations of the owner. So if the owner fails to live up to its obligations under Article 5, for example, refuses or fails to ever get a survey to the architect so the architect can properly design, if the architect fails to meet the deadline dates to complete the design development, they're not meeting schedule, either one of those could be argued to be a substantial breach of the agreement and allows either party to trigger a termination under 9.4. Now, as I said, under 9.3, I strike 9.3. I don't want the architect to terminate it except for non-payment. And on this, I also strike 9.4 because I want to make sure that the owner, and I add in 9.4 revised termination for cause, that basically says the owner can terminate in not less than 7 days if the architect fails to substantially perform. Because once again, I'm paying the money as the owner, but the architect can get compensated for suspension. There's other things that can protect the architect, but the owner could be in much significantly greater financial duress if you give the architect the ability to terminate other than non-payment. But that's my revision when I represent an owner. When I represent an architect, I leave this as is. 9.5, the owner may terminate the agreement upon not less than 7 days written notice for the owner's convenience and without cause. So this is important. Again, you don't ever want to terminate, but what 9.5 says is, if I'm in a situation where the marriage, the relationship between owner and architect is not working out right, but it may not be so great as that the architect has breached. Are they hitting their dates? Sometimes they hit their scheduled dates, sometimes they don't. Are their budgets, are their estimates of the cost of the work right? They're close, but they're not 100%, but there's just problems. Is the design what I wanted? No, they're not really relating to me. But if none of the actions of the architect result in a substantially failure to perform, which is required in 9.4, how do I get out of this bad marriage? I'm stuck with an architect that's doing bad work, that we can't hit dates, but we can, and we're not sure. And I just have this bad feeling, and I'm spending millions of dollars on architectural fees, and I'm going to spend tens of millions of dollars on my building. How do I get out? Well, 9.5 says you can terminate for convenience. You don't have to have the cause. You don't have to have the substantial failure under 9.4. You can just under 9.5 say, I'm terminating you for convenience. And I think that's important that the owner always has that, because it's the owner's money, it's the owner's project, and the owner, while they don't want to terminate for convenience, sometimes has to get out of the bad marriage. And so that's the situation you kind of have to take a look at. Any questions on that? 9.6 just talks about how you're going to get paid for reimbursable expenses, so once the termination happens, everything else. 9.7. Termination expenses, so this is a defined term, are in addition to the compensation for the architect's services. So you do work through August 1st, and there's a termination where the architect should get paid for its work through August 1st. But there may be other costs to terminate, whether they had someone on the project site and they had to pull them out or whatever else. So there's different termination expenses. And so we have to define that. So it's attributable to the termination for which the architect is not otherwise compensated, plus, and here's the big one, if you're an architect, plus an amount for the architect's anticipated profit on the value of the services not performed. This is huge if you're an architect. So if I'm you guys, if you're negotiating this, you want to try to keep this in the contract. It's often stricken, and we don't have a big argument, this last part of this provision, the plus the amount. But if you can keep it in, it's great. And the reason why is, so let's say that you're working on a project and it's going to be ultimately $1 million fee for you. And on that $1 million, your calculations that you were going to make about a 15% profit. So you're charging them hourly for your architect's workers and everything else, and you have to pay your lights and your bills and all the other stuff to keep the office running, and we'll have that in the lecture after the break. But you still are, when you're going to get $1 million, you're anticipating that profit on that is $150,000. So you start working, you start moving through, and 2/3 of the way through the project, the owner terminates you for convenience. You're like, all right, well, that sucks. I really like this project, but I'm not going to be working on it. But we can't get into litigation because they terminate for convenience. It doesn't matter whether they did something wrong or not. They're allowed to just walk away. This provision says, well, I've already been paid 2/3 of my $1 million, so of my profit of 15%, I've already probably earned 10% of that. So I've earned $100,000 of that $1 million is my profit. And even though you've terminated me, I still would have made $50,000 more in profit. You need to pay me my work through August 1st plus that $50,000, even though I'm doing nothing else for the rest of the project. I'm not going to bill you for anything else. I've billed you for $660,000 worth of work. You need to pay me $710,000 because I had $50,000 of profit that I was going to lose since you terminated me. Now, the architect's reason for that is because, look, I had it staffed. I had these people that are going to be working on this through the end of the year. You terminated me in September. There was still time left to finish out. Now I have people that were going to be busy, that were going to be making me money. Now I got to go out and find other projects for them. I can't promise that they're going to be working on something until January. Maybe I actually have a project lined up and I've promised my next client they're not going to start till January, so they have to sit idle. So I'm losing money on my people performing services, and I'm losing profit. So you promised me a project that I would be able to do the whole project through the end of the year. You terminated me early. You pay me for the work I've done, plus lost profits. That's what this is. Now, as I said, most of the time you're going to see this stricken, but in this instance, if you're the architect, do everything you can to keep it in, to get that extra profit. Okay. Any questions on fee? Termination. Okay, moving on. Article 10, miscellaneous. So this is just kind of a catch-all. We'll just kind of zip through these. So, if you have a dispute, you want to go under the Federal Arbitration Act. So now we have kind of another set of rules. We have the arbitration rules under the AAA, but you need to use the Act, which has some other elements of it. Terms of the agreement in this contract are the same as the A201. As I said, and I've talked about a couple times, the suite of documents, if it's a capitalized term here, it's the same term there. They all have the same meaning, so everybody's on the same page. Architect and owner bind themselves, their agents, and otherwise to the agreement, meaning we're all, if I'm speaking on behalf of the owner, I'm an agent. So this is this agency stuff we talked about a couple weeks ago, and now it's actually in the contract. And then neither owner nor architect can assign this agreement without written consent of the other. So let's say the architect is going to be absorbed by another company. Well, can they assign that to the new company where you have to have a written agreement from the owner? Or the owner decides that they aren't going to build the project anymore, but they found somebody else that's going to build phase 2 or whatever it is. The owner can't assign this agreement. It's between the two parties. Now, if they have written consent, it's fine, but you can't do it without the written consent. Certificates here I wouldn't worry about. 10.5. Nothing in this agreement shall create a contractual relationship or cause of action in favor of a third party against either owner or contractor, owner or architect. Meaning contractor can't sue the architect because the contractor has an agreement with the owner. A electrical engineer for the architect can't sue the owner because the electrical engineer has an agreement with the architect. This is basic contract law. But as I said, sometimes you want to put it in. So nothing, even though we talk about consultants and we talk about contractors and we talk about a bunch of third parties in the agreement, just because we talk about them, this provision says it doesn't mean that there's any cause of action between those third parties and the principal parties of this contract, the owner and the architect. 10.6. Architects shall have no responsibility for the discovery, presence, handling, removal, or exposure of persons to hazardous materials or toxic substances. So this is saying, look, you're responsible for the property, the contractor's responsible for its work. If there's toxic waste on that land, remember you did the geotech, not me. And if there's toxic, if the soils are toxic, or they have, like I said, arsenic is an example. I use that because I had a client where they discovered lots of arsenic in the soil and they had to have it removed. So all the owner's responsibility. And so the architect here makes it very clear. I'm not responsible for getting rid of the toxic waste on that site or in any of the equipment. 10.3 or 10.7. The architect shall have right to include photographic or artistic representations of the project among their promotional and professional materials. And that makes sense. And I designed it and I want to show everybody else what a good designer I am, so I'm going to put it in my brochures and I'm allowed to. Now, depending on your owner, so my project that I've been talking about, that we had the meeting with the senior members last week, we revised this provision, and we said that the architect has to get authorization from the owner before they put them any pictures of the project in the architect's professional materials, because this owner wants careful control of how their brand and their business is displayed and advertised. And so they don't necessarily have a problem with the architect saying, oh, I did this building for X, but they want to make sure that it's within the taste and the parameters that the owner normally does, as opposed to the architect can just put it out wherever they want. And they don't want the architect to try to make money off the owner's name. It's a fairly well-known company, and so they want to say, look, we want to limit your rights to do that. 10.7, even though, so 10.7 continuing on in the back half of it, so while you can do photographic and artistic representations, the back half of the 10.7 says if there's confidential or proprietary information, they can't disclose that information. They can't give that out because it's all considered confidential. And the owner, that's important because the owner, they're going to be giving financial information for the budget. There may be things about how the building operates that may be trade secrets. So there's lots of stuff that could be for the construction of a project that the owner doesn't want the public to know. So they may say, yes, you can put photographs, but no, you can't put this. And no, you can't give out this information. In fact, one of the other reasons why my client modified the first part of this provision is because any pictures of the interior of this facility potentially has intellectual property rights because the product they make is very secretive of how they do it. Their process is to them and them only. And so as a result, they don't want anybody to let this confidential information out. So, and then the final part of this, the owner shall provide professional credit for the architect on the owner's promotional materials. So sometimes this is allowed, sometimes this is not, but basically what it says is that the owner on their website or their brochures have pictures of the project. Somewhere in there they would like the owner to say in the bottom, this was designed by, whatever architects. That's what that says. 10.8. If the owner or architect receives information specifically designated by the other party as confidential or business proprietary, they need to keep that information strictly confidential. So, and they can't disclose it to anybody but their employees, those that need to know to perform the construction or consult. So obviously, you have to let your designers know and your subconsultants and the contractors, but if it says confidential or business proprietary, it must stay secret. And these are really important, often more for the owner than the contractor or the architect. But there may be some proprietary stuff that the architect provides, but more often this favors the owner. Any question on additional miscellaneous terms? One thing you'll find under Article 10 is sometimes this will get expanded. I have 10.9, 10.10, 10.11. I have other provisions that I'll add in here that kind of don't fall under any other category. So this is one area where you'll see the contract maybe increase tied to specifics of the project. So for example, when I represent Navy Pier, and when Navy Pier did the revisions, the renovations, the owner did not want to do the geotech, largely because it's not a traditional site. Obviously the pier sits out on the water and it's built on pilings and it's 100 years old and lots of stuff that is very unique about it. And so they had obligations and responsibilities that the architect had to go out and hire its own team of engineers and surveyors and examiners to make sure that they understood the condition of the land, quote unquote, the land or the pier on which the project was going to be built. And so there was a whole host of duties and obligations surrounding that additional work that normally is on the owner's side that would be in a contract between the owner and the geotech or the surveyor or whomever. And that was all then looped in and we put it into Article 10. So we had to find a spot to put it, and we we expanded Article 10 as miscellaneous provisions. Okay, compensation. So you've been doing all this work, you've got to figure out how to get paid, and there are different payment methods for the project, okay? So, for your basic services, and remember basic services, architectural, structural, mechanical, electrical, you're going to be paid as follows. And here you just put down how much the dollar is. It's the amount of it, maybe a flat fee. I'm going to get paid $150,000 to design your $1 million house. Or it may say, I'm going to get paid 10% of the cost of the work. It's $1 million house, you're going to pay me $100,000. Or it could be, I get paid hourly. So you're going to describe under 11.1, for my basic services, here's how I'm going to be paid. For additional services under 11.2, here's how I'm going to be paid. And it could be different. You could have in 11.1, I get paid $150,000 for my basic services, flat rate. 11.2, everything is going to be done on an hourly basis. Or it could be in 11.1, I'm going to be doing everything on a percentage. And in 11.2, you're going to say, these 3 additional services is a flat rate, and these 4 are going to be as a percentage, and these 4 are going to be hourly. So it's a mix or match. And when you go out and work in the field, and you'll talk to the companies that you work for, they're going to have what they believe are the best models on how to get paid. So that's why it just says insert amount or basis for compensation, because you're really not sure how that's going to be done. For additional services that arise during the course of the project, so that may come up later. So you may have in Section 4.1 additional services that everybody agrees to the beginning. I'm going to do landscape design for you. That everybody knows from the very beginning. And for the landscape design services, you're going to pay me an additional $25,000. And then later in the project, maybe the landscape design services expand, or maybe in the middle of the project you want to have some other type that you pull from the list of additional services. There's a whole, like I said, that laundry list that I talked about, that schedule. And so it may not have come up in the beginning, but it comes up in the middle. And so what you want to do when you're negotiating is you want to say, hey, let's figure out how to price that now. Most of the time you're going to see in 11.3 that the additional services come up during the course of the project. Most of the time you're going to see this is going to be either percentage for the work or hourly. I would say hourly is probably the most common. But you want to try to fill in this blank. You don't have to, but you want to try to think about filling in this blank so we know in the beginning what we're getting into in the middle. So that's how. These are architect's payments. 11.1, 11.2, 11.3. Now, 11.4 is when the architect has a consultant. The architect has that electrical engineer. The architect has the mechanical engineer. So for that, they get paid additional service of the consultants, were not included in 11.2, 11.3, plus a percentage. So for that, it says, okay, I have to hire this consultant. I have to hire a specially low voltage lighting designer. And they're going to charge me whatever they charge me. Maybe they're charging me hourly, maybe they're charging me a flat rate. So let's say that the cost is $10,000. Well, the architect says, I get those costs plus, and often this is a percentage, 10%. It's a markup. It's very common. Contractors do it all the time. They mark up their subcontractors, and architects as well. I try to get, if I'm an owner, I try to get this to be zero. It's just a pass-through cost. But sometimes the architect will get anywhere between 0.5% and 15%. I'm sorry, 5% and 15% markup here. So if it's a $10,000 fee, the architect gets paid 11. They pass the 10,000 downstream to the low voltage designer, and the architect keeps the 1,000. So that's what 11.4 says. 11.5. This is where, if we go back to the previous page, hold on. If we go back to 11.1, and we say for the basic services we're going to be paid, and let's say we put in a flat rate, $150,000. That's what you're paying me to design your $1 million house. Flat rate, $150. It's not hourly, it's not percentage, it's just $150. Well, when does the owner pay that? How do we know to pay? So what we do for that is when it's based on a stipulated sum, flat rate, or even a percentage, when do we pay? Well, we have these phases. Remember the phases we talked about, the 5 phases here. Each one of those you calculate as a percentage of the total work. So normally you're going to have schematic design is roughly 15, design development is 25, so now you're up to 40. Construction document phase is normally 40%, bidding negotiation maybe 5, and then construction phase leaves you down to the remaining 15, or however these percentages break out. And you'll know, you and your architectural firm will know that. So let's say, for ease of the discussion, your fee is $150,000. Let's say your schematic design phase was 10%. Well, at the end of your schematic design phase, you should be paid $15,000. It's just simple math. And this is kind of, again, it helps the owner and the architect understand when the money's going to come, how is it going to be paid, and what it's going to be paid. And to think about it also, if you remember way back when we were talking about in Article 3, the schematic design phase, there was that process. I'm going to do these drawings, we're going to talk about it, and I'm going to provide them for you, you're going to look at them, and then you're going to approve that I've completed the schematic design phase. I'm not going to go to the next phase of design development until I get owner's approval in writing that you're good with my schematic design. Well, that owner's approval in writing that we talked about way back in Article 3.3 or 3.2, whatever it is, once that approval in writing comes, that triggers that you get paid at this percentage, your $15,000, your 10% of the $150,000. So they're hand in glove. The architect wants approval to know that they can start working on the next phase. The architect also wants approval to know that that's when they get paid. Make sense? Okay. Well, the compensation is based on a percentage of the cost of the work. So I get paid, and that's another common way to do it. I get paid 10% of the cost of the work of the project. Any portions of the project that are deleted or otherwise not constructed, compensation for these portions of projects will be payable to the extent the services are performed on those portions. So let's talk about that. Let's see back here. So what this is saying is, I'm designing the $1 million house for you, and it's supposed to be on the cost of the work. We come in, and it comes in over budget. Well, I've designed, do I get paid on comes in at $1.1 million. Do I get paid on that? No. I get paid because we're not going to build it. It comes in too high, it's over budget. So now I have to redesign it. And it may bring down the cost of the work, but I've already worked on a portion of that. I should get paid for those services. So should we be payable to the extent the services are performed on those portions. So if you designed the $1.1 million house, you may have to redesign portions of it for free, but you still get paid for the work you've done to date. The owner can't say, I'm not paying you for the additional $100,000 worth of services. You have to be paid at least to date. And so that's going to kind of be, you're going to have to, again, when the bids come in, you're going to have to sit down with the owner and figure out. This provision rarely comes up where there's a discrepancy, where the budget is blown and you're being asked to pay for the work you've done to date, even though you have to redesign for free. But it sometimes comes up, so they wanted to spell it out in the provisions to tell you how it works. Okay, so 7, that's 11.6. So if you remember 11.5 has this percentages when it's based on the stipulated sum. 11.7 says if you're going to be doing this by hourly, so you're going to charge me hourly instead of by cost of the work or by percentage or a lump sum, you got to put in your rates. So you stick in under 11.7 your rates. Senior designer, $350 an hour. The principal $350, senior designer $275, associates at $225, whatever it might be. So you put in your rates here, and you put that in the contract. Compensation for reimbursable expenses. Well, you're going to have expenses like transportation, long distance. So there's this list here under 11.8.1 of all these costs that you're going to incur during the course of the project that you're entitled to be paid for. So this may be, you get your basic services, and then you may get your reimbursable expenses, which is outside of the price for the basic services. Depends on how you negotiate. So there's 5 on this side, on this slide, and the next slide identifies another 6 more mock-ups, models, if there's taxes, site-off expenses. All of these are lists, and these can be changed and modified, but this is kind of your standard list of what would be deemed reimbursable expenses. And so they get the cost under 11.8.2, compensation for the expenses incurred by the architect, so the actual cost of these 11 items above, plus, and there's a blank, there would be a markup. Again, this markup is anywhere between 5% and 15%. Normally, more often than not, it falls in at a 10% markup. And the simple economic reason for that is if I have to go out and pay someone to build models or to get a professional photographer, I have to incur those costs, I pay for them, I bill them to you because I get those expenses, but I have a carrying cost. I have my time to make the phone calls to set up the appointments. I have all these other kind of hidden costs that aren't the architectural design. So those carrying costs that I have entitle me to the 10% markup. That's kind of the thought process there. 11.9, this is important. So let's say, if you remember, we talked about termination, and it says that if the owner terminates the architect for its convenience under 9.5, or the architect that terminates the agreement under 9.3, and 9.3 was the suspension for longer than 90 days, the owner shall pay a licensing fee for compensation for the owner's continued use of the architect's instruments or services, and solely for the purpose of completing, using, and maintaining the project. So what this recognizes, and what this is a fair provision, is that for 9.5, the marriage may not have worked. And you don't want to have the owner start over from scratch. Again, too cost prohibitive to start from the very beginning. But it just doesn't make sense for the owner and the architect to continue to have a business relationship. And you don't want to get into litigation, so you don't want to terminate for cause. So you terminate for convenience under 9.5, and then you say to the architect, I've paid you for everything you've done to date. I will pay you for a licensing fee so I can continue to use it. And that's fair. Now, interestingly enough, though, remember, if the owner is building something and they're not using the architect, there's an argument to be made that the owner's continued use, that the architect would not be held liable for certain uses of those drawings. It depends on where they are in the process. So, if this comes up, either side, if you're representing the architect, you have to negotiate on behalf of the architect's benefit, and the owner the other way. There may be the kind of get-out-of-jail-free card I talked about earlier in Article 7. That if the owner uses the drawings, even though they've paid the licensing fee, would the architect be able to be indemnified and not be held responsible if something goes wrong after the owner has terminated? And then the same thing under termination for suspension. Well, that's the 9.3. If the architect gets the right to terminate under suspension, the owner's like, well, wait a minute. I was just trying to get financing. I understand that you're senior designer. She had this great project she wanted to go on. I'm really sad that you terminated me, but I can't stop you because the contract allows you to do that. But man, you've put me in really dire straits. Now I've got my financing, and I want the project to continue. If I can't use your drawings, I got to start over from scratch. So that's going to cost me tens of thousands of dollars, maybe millions. So this provision recognizes the other side. As long as the owner's paid its licensing fee, they get to be able to use the drawings as well. So it's trying to be fair for both parties in this situation. 11.10. This is just talking about initial payment. There would be a down payment made. Sometimes you want to seed money, start the project off. Very, very common to have an initial payment. And then 11.10.2 talks about you're going to be paid monthly on a monthly basis. This stuff will make a little bit more sense when in a later lecture after the break, we'll talk about how you operated a business and how much revenue you have to generate on a monthly basis to keep your doors open and stuff like this. But obviously you want to have all these things spelled out in the contract so that both parties know when payment's going to be made, how much, and for what reasons. So that's 11.10.2. 11.10.3. This is another very important provision for the architect. The owner shall not withhold amounts from the architect's compensation to impose a penalty or liquidated damages on the architect, or to offset funds requested to be paid to contractor for costs or changes in the work, unless the architect agrees or been found liable for the amounts in a binding dispute resolution proceeding. So what does this mean? So I've hired you to design that building for me, and you have the wall falls down. This example that I keep using. The contractor, and the owner's like, was it built wrong? Was it designed wrong? I'm not sure. And it turns out that the time that it's going to cause to rebuild the wall is going to make the project delayed. So the contractor, it makes a claim, I should be paid, because it's a big wall, I should be paid $500,000 for building this wall. So that's the contractor's claim. The owner says, yeah, you were supposed to finish this project by August 1st, and now you're going to be delayed, so I'm going to charge liquidated damages against you, and there's going to be a fight over whether the owner's entitled to its damages coming back, so you owe me, you say you're owed $500,000 for the additional work, I'm saying you're going to owe me $1 million for liquidated damages. So that's a discussion that's ongoing between the contractor and the owner. At the end of the day, though, the architect or the owner may have to pay some money, and it may be due to the fault of the architect's design. The wall fell down. We don't know if it's the contractor or if it's the architect, but we think it may be the architect. What this provision says is, yes, you may have to pay the contractor $500,000 to rebuild that wall, but you cannot withhold what you owe me for my work to offset what you have to pay the contractor. We'll figure it out. If I'm liable, I have to pay you elsewhere, and I have insurance for that and everything else. But you can't say to me, I'm not making payment on your bill because your screw-up cost me $500,000. That's what this says. Except for, of course, the architect may agree, or if there's already been a mediation or arbitration. Sometimes you have, like for my long projects that last a couple of years, if a dispute arises during the course of the project, we will try to resolve it real time as opposed to waiting to the end to finish things. And sometimes I've had decisions where a party has been found liable under an arbitration while the project is continuing. In that instance, the owner could then withhold the money from the architect. But any other instance, this provision says, if I did the work, you pay me. If I screwed up, well, we'll fight that out and pay another day, but you can't withhold this from me. So this is an important provision for the architect. As you might imagine, as the owner, I try to strike this, but it's still important, and you want to keep that in. Okay, any questions on compensation? All right. Special terms and conditions. This is an easy one. There's nothing here. This is anything else you want to add in. So I have when I represent an owner, I have like probably a dozen provisions that I stick in here that the contract doesn't address. And I stick them all in Article 12. It's different than the miscellaneous provisions that I talked about earlier, what we did for the Navy Pier project. These you could have put them here. It just depends, but this is this is the catch-all. Anything that's not in this agreement, we left a blank for you, owner and architect, to fill in the blanks. And then Article 13, this just simply identifies what's the agreement. It's got the B101, it's got a couple other ones, this E201, Digital Data Protocol, we talked about that earlier. references, there's the other provision, the other document, the sustainable exhibit, that would be also listed here. So anything that would be exhibits, a project schedule, for timing-wise, the rate sheet, anything else that's part of the agreement would be attached here. So, and that is it.